Hello, good morning, and welcome to Byjus Exam Prep. Yesterday, we initiated a discussion on Union Executive. And I told you, Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. And we have to discuss all these institutions one by one. First is the Office of the President. Now, we have chosen parliamentary form of government as against presidential form of government. That means although we have a president, but the powers of the president are to be exercised only on the aid and advice of the prime minister and the council of ministers, which means the real power is vested in the office of prime minister and his council of ministers who are elected by the people. Now, Constitution says under Article 52, there shall be a President of India, which means our office of President can never remain vacant. Somebody has to occupy this office at all times. What if there is a vacancy? We will discuss those conditions as well. But at the same time, Article 53 says all the executive power is vested in the name of the President of India. But what is this executive power? We don't know. Why? Because this term, executive power, has not been defined in the Constitution. For that, we look and take help from the judicial pronouncements, the verdicts. For example, the Ram Java Kapoor versus State of Punjab, 1955. And we also take a look at some of the writings of constitutional experts. For example, Wade and Bradley, in their Constitution and Administrative Law book. What do they write? Basically, the effect is executive power is the residue, the leftover. When we exclude the legislative powers and the judicial powers, whatever else is left, that is the executive power, which is maintaining law and order in the society, which is carrying out foreign policy, which means carrying out social and economic development of this country, which means initiating a piece of legislation, implementing that law once it is passed by the parliament. All that comes under executive power. And all this executive power is vested in the name of the President of India. That means these powers are given to the President. But we don't have to look at Article 52 and 53 in isolation. We have to look at these two articles in conjunction together with Article 74. And what does Article 74 say? There shall be Council of Ministers with Prime Minister at its head to aid and advise the President. This was the only thing that was mentioned in the Constitution, in the original Constitution. The 1976 Constitution was amended to say there shall be Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice. That means it is binding on the President to accept that advice. 2 years later, another amendment was made. 44th Constitutional Amendment Act provided the President may ask for reconsideration of that advice and shall act on the advice tendered again, which basically means the President may ask the Council of Ministers, can you please reconsider your advice? For example, you are asking me to impose President's rule in West Bengal and dismiss Mamta Didi. Can you please reconsider? She's my friend, or she's a good chief minister, or it is not legal to dismiss her. Can you please reconsider? If it is reconsidered, the government says, the Prime Minister says, okay, don't impose President's rule. Done. But if it is reiterated, again insisted by the Prime Minister and the Council of Ministers, no, you have to dismiss her, impose President's rule. I have no other option but to dismiss her, impose President's rule. Which means the constitutional position of the President becomes that the President is a rubber stamp. The President does not have any discretionary power, which means President cannot under any circumstance act on her own. She has to act on the aid and advice of the Prime Minister and the Council of Ministers. There is still an element of discretion provided that we will discuss today. Then we looked at how is this President elected. President is elected by the Electoral College in an indirect election, through a system of proportional representation system, by means of single transferable vote through secret ballot. These are the 5 steps that we explained yesterday. How is the President of India elected? If there are 2 candidates, 3 candidates, 4 candidates, any number of candidates, the candidate who gets the absolute majority, which means more than half of the valid votes polled, that person is the President of India. If we do not find somebody who gets the majority of the first preference votes, then we eradicate the last candidate, transfer his first preference votes to others. Because those who have given first preference to D, what was their second preference? We transfer those votes. That's what we call single transferable vote. Clear? Okay. Now, what is the term of office of the President of India? Normally, the term is 5 years, which means if the President is elected today, the President shall remain in office for a period of 5 years. That is the tenure of the President of India. But at any point in time, there may arise a vacancy. There may be vacancy in the office of the President. Vacancy can be because of resignation. The President, after 1 year, 2 years, 3 years, 4 years, decides to resign from her post. There will arise a vacancy. That means somebody is not there holding the office of President. But this office cannot remain vacant because Article 52 says there shall be a President of India at all times. What happens in this case, we will discuss. But vacancy can be because of resignation. Vacancy can also be because of death. Vacancy can also be if the President is removed from his office. And the term that we use for the removal of the President of India is known as impeachment. And please remember, this term is used only for the President. Which means there are various constitutional functionaries. All these constitutional functionaries are removed or can be removed from their offices. For example, Prime Minister can be removed. CAG can be removed. Judges of the Supreme Court and High Court can be removed. Chief Election Commissioner can be removed. Chairperson of the Union Public Service Commission can be removed. All these constitutional functionaries can be removed. Vice President can be removed. But President, we say, can be impeached from his office. And this term impeachment is used only and only for the President of India. But sir, what is the difference between impeachment and removal? That's also something we will discuss today. So park your thoughts. But the term of the office of the President is 5 years, which means the tenure is 5 years. But even before 5 years, there may arise a vacancy. Vacancy can be because of resignation. How will the President resign? President will submit her resignation to the Vice President. And this resignation listen to me carefully. Normally what happens, if I'm a member of Lok Sabha, as a member of Lok Sabha, my term is 5 years. But even before 5 years, I want to resign. Whatever may be the reason, I want to resign. I will submit my resignation to the Speaker of the Lok Sabha. Once the Speaker accepts my resignation, I shall cease to exist as the member of the Lok Sabha. But when I submit my resignation to the Speaker, it is not binding on the Speaker to accept my resignation. What Speaker has to do, Speaker has to satisfy himself whether this resignation is voluntary or whether this resignation is forced. Whether you are resigning on your own or whether somebody is coercing you into resignation. Once the Speaker is satisfied that your resignation is voluntary, the Speaker will accept your resignation. Once the speaker decides that no, somebody is forcing you, coercing you, luring you into resignation, I may not accept your resignation. So when a member of the Lok Sabha resigns by submitting his resignation to the speaker may not accept your resignation. It is not binding on him to accept your resignation, because the speaker has to conduct some kind of an investigation to see whether this resignation was voluntary or forced. But when it comes to the office of the President of India, such an important office that we can't leave anything to chance. In a sense, when the president decides to resign and submits the resignation to the vice president, the vice president shall accept that resignation. The vice president need not go into whether this resignation was voluntary or forced, whether this resignation is genuine or not. No, the vice president gets the resignation, the vice president shall accept that resignation. And what will vice president do with this resignation? Inform the Speaker of the Lok Sabha. But sir, why should the vice president inform the Speaker of the Lok Sabha? Can anybody tell me the answer to this question? Even if you have not read this, but please tell me, what do you think should be the answer to this question? Why should vice president send this resignation, once he accepts it, to the Speaker of the Lok Sabha? Rajya Sabha, Lok Sabha. President knows I have resigned. President sends his resignation to the vice president. Who is vice president? Chairperson of Rajya Sabha. That means Rajya Sabha is also aware now that the president has resigned. Which is the other body left? Lok Sabha. Who is the Speaker of the Lok Sabha? Who is the presiding officer of the Lok Sabha? Who is like the class monitor of Lok Sabha? Speaker. So inform all the organs of the parliament that the president has resigned. President, Rajya Sabha, Lok Sabha. That is how, as soon as this resignation is sent by the president to the vice president shall accept that resignation and accordingly inform the Speaker of the Lok Sabha. Common sense. Second, resignation can be because of death. Third, resignation can be because of impeachment, which means all these three kinds of vacancies would result in the office of president remaining vacant. In this case, what will happen? Vice president shall act as the president. Because this office of president can never remain vacant. Our constitutional scheme cannot be envisaged to run even for a brief moment without somebody occupying the post of the President of India. That means whenever there is a vacancy, the vice president will act as the President of India. For how long? What are the conditions? We will discuss slightly later, but we will discuss today. Two quick points. The president shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. And this is known as something to prevent interregnum. The term of the office of the president is 5 years. Clear? 100%. Let's say the term of the office of the president is till March 2020, for example. Now, suddenly there is COVID-19 lockdown announced throughout the country. Is it possible to organize elections? Is it possible to hold elections to the office of the president? Because for that, we have to call the members of the Lok Sabha and Rajya Sabha, members of all the state legislative assemblies come together and let's elect the President of India, which may not be possible because of the pandemic, because it will spread this pandemic. That means even if the term is over, notwithstanding the term is over, the president shall continue to remain in office as long as his successor is appointed, as long as his successor is elected. This is to prevent interregnum. And what is this interregnum? Article 52. There shall be a President of India, which means this office can never remain vacant even for a brief moment. And if it remains vacant, that is what we call interregnum. To prevent this interregnum, this president, even if your term is over, please continue. Continue as long as your successor is elected. Once your successor is elected, you will go, your successor will occupy this post, because this post can never remain vacant. Any resignation addressed to the vice president shall forthwith be communicated by him to the Speaker of the Lok Sabha, and this is the point that we have discussed. Clear? Article 57 then talks about eligibility for re-election. If you look at United States of America, Bill Clinton was the president for 2 terms. After that, no. George W. Bush was the president for 2 terms. And every term of the US president is for 4 years. After that, you can see him playing golf, but he does not contest again. Barack Obama, president of US for 2 terms. Each term lasts 4 years, total 8 years. After that, he's having a podcast on Netflix, Spotify, writing a book, giving his voice to a documentary, spending time with Michelle Obama and the kids, but he's not contesting again. Which means in United States, there is a restriction that the president can hold office only for 2 terms. After that, no. That means the president can be re-elected only once in United States of America. Re-elected only once. Because first you are elected for 4 years, then you can be re-elected only once for another 4 years. After that, you are ineligible to contest election to the post of the President of the United States. But can these 2 terms be consecutive? Or there can be a gap? What does that mean? Donald Trump became the President of the United States of America, remained in office for 4 years, contested again, but lost to Joe Biden, which he says there is cheating. But whatever it is, lost the election. Can Donald Trump contest elections again? Yes. Why? Because Constitution of United States says the president can be re-elected to the office of the president for 2 terms, re-elected. Which means if you are not getting re-elected, you can continue contesting elections. You can continue contesting elections as long as Trump Towers exist, as long as Donald Trump exists, if you're not getting re-elected. But if Donald Trump is getting re-elected again, he can remain in office only for further 4 years. After that, he cannot contest elections again. Because the Constitution of United States bars the election of the same person more than twice to the office of the president. Similarly, Irish Constitution prohibits re-election for more than 2 terms. More than 2 terms, there can be no re-election after that. But in India, the president can be elected, can be re-elected, can be re-elected n number of times. There is no bar. But then, sir, why was APJ Abdul Kalam not re-elected? Because he did not contest the election. Because there was not popular support for him. One political party was supporting, the others were not. But that does not prohibit him from contesting again. Or that did not prohibit him from contesting again. Dr. Rajendra Prasad was the president for 2 terms. Srimati Draupadi Murmu can also contest the election again after 5 years. You can contest and get re-elected n number of times. There is no such limit on the re-election of the president, the kind of limit that we see in Ireland, the kind of limit that we see in the United States of America. Done? Something else. What are the qualifications? Who is qualified to contest the election to the office of the President of India? First is the universal qualification. You have to be the citizen of India. But it does not say that you should be the citizen of India by birth only, then you can contest the election. No, any citizen of India, even if you are a naturalized citizen of India, you can contest elections to the office of the President of India. But in United States, only a citizen by birth can become president of the United States of America. That means somebody who is a naturalized US citizen, who was born somewhere else, but later on became the citizen of United States, that person cannot become the president of the United States, cannot contest the election to the office of the president of the United States. Sir, what about Barack Obama? His parents may be Kenyans, but he was born in United States. Mr. Vivek Ramaswamy, his roots may be Indians, but he was born in United States. So only a citizen born in United States can contest election to the office of the President of the United States. Done? In India, if you are a citizen of India, if you have completed 35 years of age, you are qualified to contest elections to the office of the President of India, provided you are also qualified to become a member of the Lok Sabha. Who is qualified to become a member of the Lok Sabha? There are thousands of citizens of India, thousands, if not lakhs, who are the citizens of India, who have completed 35 years of age as well, but they are still ineligible to contest election to the office of the President of India. Why? Because although they are the citizens of India, but they have not enrolled themselves in any electoral role. For example, this is my constituency, Varanasi constituency, for example. I should have been mentioned in the electoral rolls of Varanasi. That means I should be a registered voter in the Varanasi constituency. Because I was born there, I was brought up there, I was residing there, I am a resident there. But I have not enrolled myself as a voter. I don't have a voter ID card. Which means although I am a citizen of India, I have completed 35 years of age, but since I am not a registered voter in any parliamentary constituency of this country, which means I am ineligible to contest election of the Lok Sabha, which means I am not qualified to become the president. I am not qualified to contest elections to the office of the president. In order to contest elections, I should be the citizen of India, should have completed 35 years of age, should be a registered voter in any parliamentary constituency of this country. Any parliamentary constituency. Out of 543, you should be the registered voter in any one. You are qualified. Further, you should also not be holding something known as the office of profit. If you are holding an office of profit, you cannot contest election to the office of the president. And what is this office of profit? We will discuss in union legislature. Because once we will discuss union legislature, once I will tell you what is the real job of the legislature, what do legislators do, there we will discuss what is this office of profit. Till then, just keep in mind what are the qualifications in order to contest election to the office of the President of India. You should be the citizen of India, must have completed 35 years of age, should be a registered voter in any parliamentary constituency, which means you should be eligible to contest or become a member of the Lok Sabha, and at the same time, you should not be holding any office of profit. Once you are elected, let's say election took place, there were two strong candidates, Shri Yashwant Sinha and Srimati Draupadi Murmu. Both were eligible, both contested elections. Election took place in an indirect fashion by the Electoral College through the system of proportional representation system by means of single transferable vote through secret ballot. But ultimately, once we counted the votes, once we counted the first preference votes, we realized that majority of the first preference votes are in favor of Ms. Murmu. and she became the President of India. But before she can occupy this post, because President Ramnath Kovind is still there, occupying that post, occupying that chair. But before President Draupadi Murmu can occupy her post, she has to be administered oath or affirmation. What is this oath or affirmation? Oath is for believers. Those who believe in religion. Affirmation is for non-believers. Take an oath. If it is an oath, I swear in the name of God. If it is an affirmation, I solemnly affirm. Because affirmation is for non-believers. Oath is for believers. And what is the oath? I swear in the name of God that I will bear true faith and allegiance to the Constitution of India as per the law established, and that I will faithfully and conscientiously discharge the duties of my office. And the oath of the president says something important. She takes the oath to preserve, protect, and defend the Constitution. She takes the oath that she will devote herself to the service and well-being of the people of India. This oath is unique because only the president takes the oath to defend the Constitution. That's something unique for the oath of the president. And who administers this oath? Chief Justice of India. What if Chief Justice of India is not present? We have 34 judges in the Supreme Court, headed by the Chief Justice of India. This Chief Justice of India will administer oath or affirmation to the president. If Chief Justice is not present in the sense the Chief Justice is not there, Chief Justice is outside, Chief Justice has resigned, Chief Justice is dead, Chief Justice has been removed, then who is the next senior judge of the Supreme Court? That person will administer oath or affirmation to the president. What if this person is not also present? There would be somebody in this line out of these 34 judges who will be present and who will administer oath or affirmation to the President of India. And this oath is for believers, affirmation is for non-believers. But once you are administered oath or affirmation, then you occupy the post and your normal term is for 5 years, which means your tenure is 5 years. But even before 5 years, you may be impeached. Impeachment under Article 61 of the Constitution. An impeachment, we say the president can be impeached on the grounds of violation of the Constitution. Let's say, for example, a student of a college can be rusticated from the college. Why? On various grounds. If you have committed these things, if you are not regular to the school, if your attendance is zero, if you have failed consecutively, these are the grounds on the basis of which you can be rusticated from the college. For example, an individual, your father tells you that if you don't clear this examination, I will throw you out of the house. Then you will have to fend for yourself. That means on the ground of not clearing the civil services examination, you can be thrown out of your house. That means what are the grounds on the basis of which action can be taken? The President of India, on what grounds can the President of India be removed from his office? And the term we use for that is impeachment. On what grounds? Grounds are violation of the Constitution. But this phrase, violation of the Constitution, what does this phrase exactly mean? Not defined in the Constitution. That's problem number one. We don't know what is violation of the Constitution because this term, violation of the Constitution, has not been defined. Second, no president yet has been impeached. Not just not impeached, we have not seen even a process of impeachment initiated against any president. That is the dignified office of the President of India. But the president can be impeached on the grounds of violation of the Constitution. But what is this term violation of the Constitution? We don't know because it is not defined. We may also not know because we have never had a situation where the president was impeached, so that we could tell you that the president was impeached on this ground and this ground is the violation of the Constitution. But we can say impeachment on the grounds of violation of the Constitution would mean, what if the president goes against the aid and advice of the Prime Minister and the Council of Ministers? Because we say there shall be Council of Ministers with Prime Minister at its head to aid and advise the president, who shall act on that advice, provided you are asking for reconsideration of that advice. But if the same advice is given again, it's binding on you. What if the Prime Minister is advising the president, please appoint this gentleman as the Attorney General for India, and the president instead appoint me? Which basically means you have gone against the aid and advice of the Prime Minister, which is binding on you. That would mean violation of the Constitution. And on that ground, you can be impeached from your office. But what is this process of impeachment? Now listen to me carefully. This process can be initiated in either Lok Sabha, or this process can be initiated in Rajya Sabha as well. Clear? Let's assume this process is initiated in Rajya Sabha. 1/4 members of Rajya Sabha will write to the chairperson of Rajya Sabha. Dear chairperson of Rajya Sabha, this is a notice. We want to impeach the President of India on the grounds of violation of the Constitution. And these are the grounds we think on the basis of which the President should be impeached. This notice is given, this motion is given to the Vice President. Now, Vice President's eyes lit up. He is now praying to God 1,000 times a day. My God, this should happen because I can occupy this post then. Immediately what Vice President does? Sends notice to the President. This is a 14-day notice. That means as soon as the Vice President, who is the chairperson of Rajya Sabha, gets this motion that more than 1/4 of the members of the Rajya Sabha, they want to impeach you, the Vice President sends notice to the President. Dear President, please be ready. At any point in time, you may be impeached from your office. These are the grounds on the basis of which members want you to go. Prepare defense for yourself. Once that 14-day period is over, voting takes place in Rajya Sabha. If in Rajya Sabha, this motion or this proposal calling for the impeachment of the president is passed, if it is passed, previously we discussed more than half of the members present and voting, simple majority. More than half of the total membership of the House, absolute majority. 2/3 of the members present and voting. Now we are talking about toughest majority in the Constitution. A special form of majority. More than 2/3 of the total strength of the House. Not more than 2/3 of the members present and voting. More than 2/3 of the total strength of the House. That means more than 2/3 of 245 in Rajya Sabha. If this proposal to impeach the president is passed by Rajya Sabha by not less than two-thirds of the members present and voting, then this matter will go to Lok Sabha, to the other house. Now, in this case, Lok Sabha will investigate. Lok Sabha becomes an investigation house. Lok Sabha will now investigate all the allegations against the president, which Rajya Sabha has leveled, saying that these are the things which constitute violation of the constitution. Lok Sabha will investigate. After the investigation, if Lok Sabha passes a resolution by the same majority, by not less than two-thirds of the members present and voting, the president shall be impeached from his office. And why do we call this impeachment? Two things you have to keep in mind. One, it's a quasi-judicial process. Second, no involvement of the executive. What does that mean? The president, normal term tenure is 5 years. But even before 5 years, there may arise a vacancy. For example, the president may resign. For example, the president is dead. Or, for example, the president is impeached from his office, basically removed from his office. Because once you are appointed or elected for 5 years, then you have to abide by the constitution. Because you swore, you took an oath that I will preserve, protect, and defend the constitution. What if now you are violating the constitution? You can be impeached from his office. And for that, there is a process mentioned under Article 61. And the process is, this process can be initiated in either Lok Sabha or Rajya Sabha. Now, let's assume this process is initiated in Lok Sabha. 1/4 members of Lok Sabha will write to the Speaker of the Lok Sabha. Dear Speaker, we want to impeach the President of India. These are the grounds. Speaker will send a 14-day notice to the President that respond to this notice within 14 days. These are the allegations against you. Once that 14-day period is over, then there is voting in Lok Sabha. If this proposal to impeach the president is passed by not less than two-thirds of the total strength of Lok Sabha, then this matter goes to Rajya Sabha. And now Rajya Sabha will act as an investigation house. Rajya Sabha will investigate all these allegations of the violation of the constitution against the president. May even ask the president, please come, have a seat in Rajya Sabha. Please tell us what is your defense. Or the president may send his lawyer to defend himself in Rajya Sabha. So basically, after that investigation, Rajya Sabha can declare, yes, the president is guilty of violating the constitution. And if Rajya Sabha also passes a resolution by not less than two-thirds of the members present, of not less than two-thirds of the total strength of the House, the president is impeached from his office. Which means it's a quasi-judicial process. Not completely judicial, but quasi-judicial. Not completely legislative, but also judicial in nature. In a sense that the members of the legislature, this legislature as a body, becomes like a court. The members of the legislature become like judges to decide whether you are guilty or not. But since they are not judges, we call it a quasi-judicial body or a quasi-judicial process. And second, there is no involvement of executive. Why is the Chief Justice of India removed and not impeached? Listen to me carefully. This is the difference between impeachment and removal. For example, the Chief Justice of India can also be removed in the same process. One house passes a resolution by special majority. The other house passes a resolution by special majority. After investigating whether you have indeed committed misbehavior or whether you are indeed incapacitated, because the Chief Justice can be removed on the grounds of proved misbehavior or incapacity. If the Chief Justice has committed misbehavior, or once the Chief Justice was appointed, he was in strong mind, but now he has gone insane, unfortunately. Now, an insane person, we may have sympathies for you, but we cannot entrust you with the job of running the Supreme Court, which means you can be removed from your office. But when both houses of the parliament pass a resolution accepting yes, this Chief Justice should be removed, accepting yes, this judge should be removed, accepting yes, this CEC should be removed, accepting yes, this particular individual constitutional functionary should be removed. But ultimately, the matter goes to the president. President will sign on this matter, and ultimately, Chief Justice is removed. That means basically the final order of removal is issued by whom? By the executive, by the president himself. Because the president has appointed the Chief Justice, the president can remove him. President has appointed the chairperson of the UPSC, president can remove him. President has appointed the judge of the Supreme Court and High Court, president can remove him. But basis the resolution passed by parliament. So that is also a quasi-judicial process. But the final order of removal is issued by the executive, is issued by the president. That is why we call it removal, because removal is done by executive. President issues the order of removal, Chief Justice is removed. President issues the order of removal, judges of the Supreme Court and High Court are removed. That's why we call it removal. We don't call it impeachment. But impeachment of the president is once one house passes a resolution by not less than 2/3 of the total strength of the house, then the other house becomes an investigation house. Then when this house also passes a resolution by 2/3 of the total strength of the house, on the same instant, the president is impeached forthwith. That means we don't have to issue any executive order to impeach the president. The moment the other house passes a resolution, the president stands impeached from his office. That is why we call it a impeachment. We don't call it removal. And this is how the president of India is removed, impeached from his office. Can the Supreme Court interfere in impeachment of president? Normally, Supreme Court should not. But we have discussed, and we will discuss in great detail in judiciary, that Supreme Court of India can do anything except convert a man into a woman and a woman into a man. Or we can go a step further and say Supreme Court can do even this. Convert a man into a woman and a woman into a man. Because that is the power of the Supreme Court. Supreme Court can interfere. But maybe only after the process is over. Supreme Court cannot stop this process. But once this process is over, once the president is impeached, the matter can reach the Supreme Court if there has been bias, if the processes were not followed. So judicial review is part of the basic structure. So even this action of the parliament may be subject to judicial review. Here are two things that you have to keep in mind. One, state legislative assemblies do not participate in impeachment. Although they played a very important role to elect the President of India, because they are also part of the Electoral College, but they have no role when it comes to impeachment of the President. And second, nominated members participate in impeachment and not in elections. President shall be impeached on the grounds of violation of the Constitution if a resolution is passed by both houses of the parliament by the majority of not less than 2/3 of the total strength of the house. House includes nominated MPs as well as elected MPs. So these nominated MPs who played no role whatsoever in electing the President of India, now they have a role in impeaching the President of India because they are part of the parliament. And state legislative assembly MLAs who played a pivotal role in electing the president, they will play no role in impeaching the president. Why? Because they are not part of the parliament. That is how the president is impeached from his office. Now let's look at the powers that are available with the President of India, and we will categorize powers into executive powers, legislative powers, financial powers, judicial powers of the president, veto powers of the president. All this we will discuss. First up, what are the executive powers? Executive powers deal with, for example, appointments to various constitutional bodies or appointments to various institutions. For example, appointment of the Prime Minister is the executive power of the President. When the President has the power to appoint the Prime Minister, what sort of power is this? It's an executive power, appointment. But only on the advice of the Prime Minister, other Council of Ministers can be appointed. Which means if the Prime Minister wants Mr. Amit Shah as the Minister, President cannot appoint me as the Minister. Any name which is recommended by the Prime Minister, only that name can be appointed as a Minister by the President. That means in appointing the Prime Minister, yes, the President may have a discretion, which we will discuss today. The President may appoint anybody as the Prime Minister. Can President today appoint me as the Prime Minister? Yes. But whether I will survive or not, that remains a question. But once I am appointed as the Prime Minister, only on my advice, other Council of Ministers can be appointed. That's the executive power of the President. Executive power of the President is appointing the Attorney General. It should not be of. Attorney General for India. That is the executive power. But the President can appoint the Attorney General only on the advice of the Prime Minister and his Council of Ministers. The President does not have a discretion when it comes to these executive powers. Appointment of the CAG, appointment of the Chief Election Commissioner, other election commissioners, the chairperson, members of UPSC, appointment of governors, the chairman and members of the Finance Commission, all these are executive powers. And all these executive powers are to be exercised only on the advice of the Prime Minister and his Council of Ministers. Because there shall be a there shall be a Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice. So when we look at the powers of the President, because we say under Article 53, all the executive powers are vested in the name of the President of India. What are these executive powers? One example of executive powers are the appointments to various bodies. Appointing a Prime Minister, appointing the ministers, appointing Attorney General, appointing CAG, appointing chairperson of UPSC, all these are the executive powers. Appointing the governors, these are the executive powers, and all these powers are with the President. But the President is a rubber stamp. President cannot exercise these powers on his own. The President does not have a discretionary power. All these powers are to be exercised by the President only on the advice of the Prime Minister and his Council of Ministers. And what are the other executive powers? We will discuss one by one slightly later. But when it comes to legislative powers, financial powers, judicial powers, emergency powers, we will discuss them separately. Why separately? Because to understand what are the legislative powers, first we need to understand what is a legislature. Who all are part of the legislature? What is the job performed by the legislature? Similarly, when we have to understand the financial powers, for that I have to first tell you what is a money bill, what is a financial bill, what is a budget. That we will discuss in legislature. If I have to tell you what are the emergency powers of the President, for that I have to tell you what are the powers of the states. Then we can discuss what are the emergency powers. If I have to tell you what are the judicial powers of the president, for that I have to also discuss the office of governor, because governor also has some judicial powers. So we have discussed executive powers, but not in its entirety. We have not discussed legislative, financial, emergency, and judicial powers. Why? Because we will cover them separately over a period of time. Because I'm not going anywhere, you should also not go anywhere. You should come back. But what are the other powers? For example, military powers. We say the president is the supreme commander of India's armed forces. We say it is the president who has the power to declare war and conclude peace. But here also, it is only on the advice of the Prime Minister and his Council of Ministers. President, come here. Declare war on China. Sure. Once the president declares war on China, president is the supreme commander of India's military forces. That means the army, the navy, the air force. But real power is exercised by the Prime Minister. Once the president declares war on the advice of the Prime Minister, then all these three organs, Air Force, Navy, Army, can be utilized, mobilized for this war, but on the directions of the Prime Minister. Because although these are the powers given to the president, but president does not exercise powers on his or her own. She exercises all these powers on the advice of the Prime Minister and his Council of Ministers. And tomorrow, after some time, we may also want to conclude peace. We may renounce war and conclude peace with China or Pakistan or any other country. That is also the power of the president, exercised on the advice of the Prime Minister and his Council of Ministers. Then there is something known as veto power. And what is a veto power? This is related to bills. What is a bill? Bill is a proposal. Any bill, if it is passed by both houses of the parliament, then this bill is sent to the president. Once the president signs this bill becomes an act. Because lawmaking is the job of the parliament. Parliament consists of president, Rajya Sabha, Lok Sabha. That means this bill, in order to become a law, shall be passed by all the organs of the parliament, which includes president, Rajya Sabha, Lok Sabha. Which means when both the houses pass this bill, it is sent to the president for signature. Once the president gives his assent or her assent, this bill becomes a law. Article 111 talks about something. What does it say? It talks about assent to bills. Whether the bills can be assented to by the president or not, whether the bills can be signed by the president or not. It says once the bill is passed by both houses of the parliament, what are the options available with the president? A, president may give her assent. President may withhold her assent. President may send the bill back for reconsideration. If it is not a money bill. What are the options? 11 says, when a bill is passed by both houses of the parliament, number one, the president may give her assent. That means the president may sign this bill. Once the president signs this bill becomes an act, it can now be implemented. No problem, no controversy whatsoever. Or the president may say, I am withholding my assent. The president may publicly declare that I'm not signing this bill. In this case, the bill is dead and cannot become a law. Sir, what is this veto power? You might have heard that there are 5 permanent members of the United Nations Security Council. Are you aware of that? United Nations, it has one organ known as United Nations Security Council. United Nations Security Council has 5 permanent members with veto powers. Who are these 5 permanent members with veto powers? United States, United Kingdom, France, China, and Russia. That means, what if tomorrow a decision is to be taken, a security decision is to be taken, whether, let's say, Masood Azhar is to be declared a terrorist or not, whether we should take action against Hamas or not, whether United Nations should take an action against Israel or not, whether we should launch a war on Iraq or not, because Iraq possesses weapons of mass destruction. For that, all the security decisions are to be taken by this Security Council. What if 4 members of the United Nations Security Council, permanent members, France, US, UK, as well as China, they are in favor, yes, that we should take action against Russia, because Russia has waged a war against Ukraine. But Russia itself is the permanent member of the Security Council. If Russia says, no, you cannot take action against Russia because Russia is me is Russia, Russia everywhere, United Nations Security Council cannot act against Russia because Russia has now vetoed it. That is what we call the veto power. Similarly, when a bill is presented to the president may give his assent to this bill, saying the bill becomes a law. Or the president may withhold her assent. She can publicly declare, that means issue a public notification, saying, I publicly declare I am not going to sign this bill. That means the Secretariat of President will issue a notice, will issue a resolution saying the president has declared that she is not going to sign this bill. She publicly declares it. I'm not going to sign this bill. That bill is dead. It can never become a law. This form of decision taken by the president to publicly declare that I'm not going to sign this bill, this is what we call an absolute veto. But on one hand, we say the president does not have any discretion. The president is a rubber stamp. And on the other hand, we are saying that president has such an important power that she can say, I'm not going to sign this bill is dead, it can never become a law. How do we reconcile these two positions? For that, argument number 1 is, on executive matters, president has no discretion. But on legislative matters, Constitution explicitly gives power to the president. If it was an executive matter, for example, appointing a governor or appointing the ministers, on executive matters, any advice of the Prime Minister and his Council of Ministers is binding on the president, which means president does not have a discretion. But when it comes to legislative matters, Constitution itself has said, under Article 111, that when the bill is presented to the president may give her assent, the president may withhold her assent, publicly declare that I'm not going to sign this bill. That bill is dead, it can never become a law. So this is an explicit provision in the Constitution. But there are other constitutional experts who say, how do we reconcile Article 111 with Article 74? What does that mean? Article 74 says there shall be Council of Ministers with Prime Minister at its head to aid and advise the President. Who shall act on that advice? What if there is a bill which is passed by both houses of the Parliament and the Prime Minister advises the President, sign this bill? What if the President says, I have the power under Article 111, I will publicly declare I am not going to sign this bill? Can this be the ground on the basis of which the President can be impeached, saying you have violated the Constitution? Because what will prevail, Article 74 or Article 111? On this, constitutional experts say the President has the power. The President may publicly declare, I'm not going to sign this bill. This bill is dead. It can never become a law. Because this is an explicit power under Article 111. Any advice of the Prime Minister and his Council of Ministers in executive matters is binding on the President, but not on legislative matters, not on giving signature to bills. So the President may refuse to sign a particular bill, publicly declaring, I'm not going to sign this bill is dead, it can never become a law. But there are others who say, no, if there is a bill which is pending with the President, if the advice is given by Prime Minister and his Council of Ministers that you should sign this bill, the President should sign this because he does not have a discretion. And there are other constitutional experts who say that this absolute veto can be used in two instances. Instance number one, on the advice of the Prime Minister and his Council of Ministers. Second, if the bill itself is unconstitutional. Imagine a private member's bill. What is a private member's bill? A bill, if it is introduced by a minister, becomes a government bill. A bill which is introduced by a non-minister becomes a private member's bill. Couple of days ago, Supreme Court said, same-sex couple, they do not have the right to marry. The government is against it because that was the position taken by the government before the Supreme Court, saying we don't agree with same-sex marriages. If at all we have to allow same-sex marriages, for that law should be passed by Parliament. Parliament is the place where such decisions should be taken, not in the judiciary. In fact, Kapil Sibal also supported the government on this matter. He was on the side of the government when he was hearing this case, when he was arguing this case. And he was representing Jamiyat-e-Ulama-e-Hind, because they had asked Kapil Sibal to present their side of the story before the Supreme Court, saying we don't want same-sex marriages. Which means the government is not in the favor of legalizing same-sex marriage. But imagine a situation. We have elections to 5 states. Telangana, Chhattisgarh, Madhya Pradesh, Mizoram, Rajasthan. What if the members of the BJP, the ministers and the MPs of the BJP, they are campaigning in all these states, taking out rallies after rallies and asking people to vote for BJP in these 5 states. And there is a session of the Lok Sabha continuing as well. Suddenly there is a bill. Although this is a difficult proposition, but hypothetically, let's assume that there is a bill which has been introduced in Lok Sabha calling for legalizing same-sex marriage. For example, Congress has introduced this bill that we want to pass a bill legalizing same-sex marriage. This bill will be brought up for discussion and voting in Lok Sabha. And now voting will take place. Now, the members of the BJP, which are normally in majority, they are in minority. Why? Because their MPs, their ministers are campaigning for votes in different parts of the state, which means opposition has an upper hand, which means in this Lok Sabha, this bill is passed by simple majority. Majority of the members present and voting. Because members of the BJP are not present, members of the opposition are present, they vote, and ultimately this bill is passed. And then this bill is sent to Rajya Sabha, where opposition also has a voice. Opposition gets this bill passed in Rajya Sabha, then this bill is sent to the president for signature. And suddenly the government wakes up. Oh my God, what has happened? This bill, which legalizes same-sex marriage, has been passed by both houses of the parliament. Now it is waiting for the president's assent. If this bill is assented to by the president, that means we have to implement this law. But we don't want to implement this law because we are not in favor of legalizing same-sex marriage. Suddenly there is a crisis meeting in the BJP, the ministers, prime minister. What do we do? What do we do? How can we allow this? Why were you not present? You only told us to go and ask for votes to campaign. No, you can't do this. You should have been present. Where is the speaker? Why did you allow voting on this bill? I will not leave you. I will teach you a lesson. Next elections, you will not contest the elections. Whatever it is. Somebody advises the prime minister, sir, whatever happened, happened. Now look at the repercussions. Do something. Prime Minister picks up the phone, dials the president, says, my advice is don't sign this bill. There's a bill which has been passed by both houses of the parliament legalizing same-sex relationship, same-sex marriage. That bill is presented to you. It's my advice, don't sign this bill. And publicly declare, I'm not going to sign this bill. President, if he accepts, the president will say, I publicly declare I'm using an absolute veto. I'm not going to sign this bill. This bill is dead. It can never become a law. That means this absolute veto can be used by the president on the advice of the prime minister and his council of ministers. That is use number one of this absolute veto. And second, if the bill itself is unconstitutional. Sir, have we used this absolute veto ever? Yes. In 1990s. Mr. Venkatraman was the president of India. There is something known as money bill. Which is introduced in Lok Sabha on the recommendation of president. We'll discuss what is a money bill later on Tuesday. But any bill which deals with money matters is a money bill. We have a fund known as the Consolidated Fund of India where all the money is deposited. Almost the entire money is deposited. If we have to withdraw money from that, we need to pass a money bill. And this money bill can be introduced in Lok Sabha only on the recommendations of the president. That means without prior recommendation of the president, you can't introduce a money bill in the parliament, in the Lok Sabha. In 1991, on the last working day of Lok Sabha passed a bill increasing the salary of the ministers and legislators. Any bill which talks about money matters. Increasing the salary of MPs and ministers is also money matter because it involves salary. Salary is money. This bill should not have been introduced in Lok Sabha without the recommendation of the president. Now, what Parliament has done, Lok Sabha on its last day of functioning is passing a bill calling for an increase in the salary of legislators and ministers. Rajya Sabha also passed this bill. This bill is now sent to the president. President looks at this bill. Oh, you want to give yourself a raise? You want to increase your salary as well as the salary of the ministers? I'm not going to sign this bill. Why? Why? Is the salary too high? We can reduce it. No, this is a money bill. Without my recommendation, you should not have introduced this money bill in the parliament. So this bill is blatantly unconstitutional. Because you have introduced this bill without my prior permission, without my recommendation. I'm not going to sign this bill. This bill is dead. It can never become a law. So experts say these are the two instances where the president can use his absolute veto. One, on the advice of the government itself, or if the bill is blatantly unconstitutional. But what is an absolute veto? Article 111 talks about assent to bills. When a bill is passed by both houses of the parliament, sent to the president, what are the options available with the president? The president may give his assent, the president may withhold his assent. And withholding the assent means the president publicly declares, I'm not going to sign this bill is dead, it can never become a law. And that is what we call absolute veto. But sir, this absolute veto is absolutely not understandable. Because on one hand, you said president is a rubber stamp, he does not enjoy any discretion. Then how can we say that the president has this power that he can declare or she can declare publicly, I'm not going to sign a bill? President has no discretion when it comes to executive matters. In legislative matters, the president can have his own power. But constitutional experts say there are two important use cases of absolute veto. Absolute veto can be employed by the president on the advice of the prime minister, specifically when it comes to a private member's bill. Or the president may use absolute veto when a bill which is presented to the president is blatantly unconstitutional. Clear? So, is this not a constitutional amendment act? So, can a private member introduce a constitutional amendment act like Shashi Tharoor did to Article 377? Pankhuri, first, yes, Shashi Tharoor did introduce a private member's bill to amend Section 377. It's not Article 377. Section is related to an ordinary law passed by the parliament. Article is related to the constitution. Section 377 is of the law Indian Penal Code. It's not a constitutional amendment. Similarly, Special Marriage Act is not there in the constitution. Special Marriage Act is a law passed by the parliament in 1954. It is an ordinary law. And an ordinary law, it can be a private member's bill as well, it can be a government bill as well. In fact, for a constitutional amendment bill also, it can be a private member's bill, it can be a government bill. That means this proposal to amend the constitution can be initiated by a private member, can be initiated by the government minister. Presidents have not been using their powers. If I was the president, and if a bill is passed by both houses of the parliament, I have the discretion to decide whether to sign this bill or not. But I don't want to unnecessarily interfere with the government's functioning. Right? So if there is a proper bill, proper procedure has been followed, I will give my assent because I don't want to disturb. And I will give you more instances. Please wait. I'll come back to you in some time. And after some time, matter if the same of the parliament send the bill back for reconsideration. If a bill has been passed by both houses of the parliament, sent to the president, president looks at this bill and president says, no, these are my objections for this bill. Please reconsider this bill. But if the same bill is sent again without considering the objections of the president, or with considering the objections of the president, doesn't matter. If the same bill is sent again to the president, president has no other option but to sign this bill. This is what we call suspensive veto. That means the president may ask for reconsideration, may suspend the signing of this bill, but only once. If the same bill is sent again, president has no other option but to sign this bill. Has this happened? Yes, it has. 2006, Office of Profit Bill. What is an Office of Profit? I told you we will discuss in legislature chapter. But very briefly here, whoever is part of the legislature cannot be part of the executive. A legislator cannot hold any job under the executive. But there are some exceptions. For example, when I say there should be some form of separation of powers between executive and legislature as well. Although Constitution says there shall be separation of powers between executive and judiciary. But one small thread of separation of powers between executive and legislature is this office of profit, wherein we say this legislator should not hold any office under the executive. To separate the two, to separate legislature, to separate executive. But we can't strictly separate executive from legislature. Because when you say no legislator should hold office under the executive, but the office under the executive is the Prime Minister's office, and you have to be a legislator. Office under the executive is a minister's office, you have to be a legislator. So that is why we say we can't have strict separation of powers between executive and legislature. But other offices, this legislator cannot occupy under the executive. There are some offices which you can occupy, even if you are a legislator, but there are some offices which you can't occupy. Sonia Gandhi, she was a legislator, and then she was also appointed as the chairperson of the National Advisory Council. National Advisory Council was created by the executive. How can a legislator hold office under the executive? There was a debate in the parliament, lots of criticism that Sonia Gandhi should be disqualified on the grounds of violating office of profit, because she is holding an office of profit. She is holding an office under the executive while being a legislator. And Sonia Gandhi decides to resign from the Raebareli constituency. But it was not meant to be forever. I will come back because I have my people there. And who are my people? Members of the parliament. What you will do? Pass a bill known as Office of Profit Bill and mention that this National Advisory Council position, the chairperson of the National Advisory Council, is not an office of profit. When it is not an office of profit, which means a legislator can occupy this post. This bill was passed in 2006. Both houses of the parliament passed this bill. One such office which was exempted was chairperson of the National Advisory Council, which means once Madam Gandhi will come back, will be re-elected to Lok Sabha, she will then occupy her prime position as the chairperson of the National Advisory Council. Because we are saying through this law, through this bill, that this office is not an office of profit. This bill was passed, it was sent to the president. The president was APJ Abdul Kalam. When APJ Abdul Kalam looked at this bill, he applied his mind. This is wrong. This is blatantly wrong. On what grounds are you exempting this office and various other offices? Please reconsider this advice. Please reconsider this bill. So when this bill was sent to the president for signature, President Kalam had the option of either giving his assent or withholding his assent or sending the bill back. He sent the bill back to the parliament. Please reconsider. These are my objections. And the newspaper said, oops, President sending the bill back to the parliament for reconsideration. Wow. But once the same bill, without any changes, was passed by the parliament again, it was sent to APJ Abdul Kalam as the president. President said, oh, this is the same bill which I objected to. But since the same bill has been passed again by the parliament, I have no other option but to sign this bill. And President signed this bill. But President signed this bill after a delay. And what was the delay? 13 days. Which in today's environment you can say it's a very quick decision. Because there are some bills which are pending with the governor of Tamil Nadu for years. Governor of Telangana is not signing a bill at all and KCR wants to go to the Supreme Court. But those were different times, constitutional times. And President APJ Abdul Kalam writes in his autobiography, He says, when this bill was sent to me, I could have used absolute veto, but I did not. Why? Because I can't go against the will of the people. Look at the logic applied by the president. I, as the president, I'm not accountable to the public. But these members of the parliament, they are accountable to the public. My only job was to raise an awareness in the society that this is not how it should be done. This is not a good bill. This is not a logical bill. My only job was to raise an awareness. It's ultimately for Parliament to decide whether they want to pass this bill or not. I cannot object. Why? Because they are accountable to the public. Let public hold them accountable, not me. If I would have said publicly that I am not going to sign this bill is dead, it can never become a law, it would have been an undemocratic thing for me to do. Because who am I? The power is with the government. The people have elected the government. So if I would have gone against the parliament, which is elected by the people, it basically would have meant I am going against the people who elected them. But I raised an awareness saying, this is not a good bill, please reconsider. But once the same bill was passed again, I have no other option but to sign this bill. That is suspensive veto. Sir, is the Office of Profit Bill not introduced with prior permission of the President? No, for this prior permission is not required. Okay. Then we have a third kind called pocket veto. There was the president of the Congress party during the emergency period, and he said, India is Indra, Indra is India. Sycophancy at its peak. Because you praise the leader to such an extent that you expect some returns from the leader as well. He's very loyal to me, you become the governor. Very loyal to me, you become the minister. Very loyal to me, you take this contract. And that's why some people are saying today that's happening with Modi ji as well. Modi ji is not asking people to praise him, but the ministers, the members of the party, they keep on praising him. He's the avatar of Lord Vishnu, stuff like that. Sycophancy. Something happened. When Srimati Indira Gandhi was the prime minister, she had a home minister. And the name was Gyani Zail Singh. Gyani Zail Singh made a famous, or should we say infamous statement. He said, if Indira Gandhi would ask me to clean the dirt, I would sweep the floor as well. Madam Gandhi can ask me to do anything, I will do that. Even if it is sweeping the floor. And for that loyalty, he was asked to contest election to the post of the President of India, and Gyani Zail Singh became the President of India. When he became the President of India, he was the President of India in 1984. Srimati Gandhi was assassinated. When she was assassinated, then somebody else should have been appointed as the Prime Minister. There are various books which say that Gyani Zail Singh was abroad at that time, and then there were people who were reluctant, saying maybe Gyani Zail Singh would not swear in Rajiv Gandhi as the Prime Minister. So should we ask Vice President to swear in Rajiv Gandhi, or whatever it is? Because at that time, Rajiv Gandhi and Gyani Zail Singh, their terms were not good, were not cordial. But it happened. Gyani Zail Singh came back. Rajiv Gandhi was sworn in as the Prime Minister. But now their relationship further deteriorated. It is argued that Rajiv Gandhi was not good to Gyani Zail Singh. Whatever the reason may be, or whether it is true or not, we don't know. But the condition is that President and the Prime Minister, they are not on cordial terms with each other. But Rajiv Gandhi had the brute majority in parliament. More than 410 MPs of Lok Sabha were from the Congress party. Because in 1984, when the election was conducted, there was a wave in favor of Congress. Why? Because in the aftermath of the assassination of Indira Gandhi. But whatever it is, Rajiv Gandhi was very powerful as the Prime Minister. Gyani Zail Singh as the president had no power basically. Ultimately, a bill was passed by the parliament known as the Telegraph Bill, which would have curtailed the freedom of speech of press. A bill was passed by the parliament and it was heavily criticized by the media, particularly Indian Express. Arun Shori, I think, was then the editor of Indian Express. Heavily criticized because this telegraph bill would have restricted the freedom of speech of press. Ultimately, this bill, even if it was criticized, was sent to the president for signature. Now, president said, "This is my payback time. I may, under Article 111, give my assent to this bill, which means the bill is passed. I don't want to do that. I may publicly declare I'm not going to sign this bill. I may use absolute veto. If I publicly declare I'm not going to sign this bill is dead. It can never become a law. But what if on this ground I'm impeached? Because whatever, whether it was constitutional or not, Rajiv Gandhi has the brute majority in the parliament. He has 2/3 of the total strength of the House in Lok Sabha. He can get me impeached. No, I should not take that route. Then what is the third option? I may send the bill back for reconsideration. But it will hurt the ego of Rajiv Gandhi. He said, how dare you send the bill back? Even then, I will impeach you. Or he may do something. He may say that from now onwards, Prime Minister will occupy Rashtrapati Bhavan and you will occupy some other flat. What will I do? I can't give my assent to this bill. I can't withhold my assent to this bill. I can't send the bill back for reconsideration as well. Then he found a loophole. Loophole is whenever Article 111 talks about President may give his assent, may withhold his assent, may send the bill back for reconsideration, but there is no time limit. The president may give her assent, but in how many days, how many hours, how many months, how many centuries, not mentioned. The president may publicly declare, I'm not going to sign this bill. In how many days, years, centuries, we don't know. The president may send the bill back in how many days and years, we don't know. There is no time limit within which the president will have to act under Article 111. Gyani Zail Singh said, this is my Eureka moment. Gyani Zail Singh is not acting on this bill at all. So the government is telling Gyani Zail Singh, please sign this bill. I will sign. I don't have ink in my pen, but I will sign. Please sign. I will. Please sign. I will. Please sign. I will. Don't worry. I will. That means the president keeps on dealing, does not sign, keeps the bill lying in his pocket or lying at his desk without taking any action at all. This is what we call pocket veto. Since there is absence of time limit within which the president will have to act, it is this absence of time limit which is what we call pocket veto. Then what happened to this telegraph bill? Gyani Zail Singh's term got over. Mr. Venkatraman became the president of India. Mr. Venkatraman, when he entered the office, he saw the bill. Oh, there is a telegraph bill lying at my desk. What is this bill doing? Now, instead of sending this bill back to the parliament, President Venkatraman sent this bill back to the cabinet of the government. At that time, the Prime Minister was VP Singh because the government also changed. VP Singh decided not to pursue this bill further, drop this bill. This bill did not become an act. That is what we call veto power. So one is absolute veto, the other is suspensive veto, the third is the pocket veto. Any questions? Please let me know. Could APJ Abdul Kalam use pocket veto in that case? Then what would have been the problem? No problem whatsoever. He could have used pocket veto. But he was a gentleman. He understood the power of democracy. If he would have used pocket veto, that would have meant that he is going against the will of the people, because after all, the will of the people through their members in the parliament. They have passed a law. Why should I go against the will of the people? That was his logic. That bill is dead, which means tomorrow you can pass another bill with same provisions. That bill, however, is dead. To sign in 10 days, can the president still use pocket veto? Yes. Should president have to sign on his own impeachment bill? No. That is why I said impeachment is a quasi-judicial process. It is impeachment, it is not removal, which means there is no role of the executive. Once both houses pass this bill, the president stands impeached. Once both houses pass the resolution to impeach the president is gone. To reconsider this bill. There is no time limit at all. Can Supreme Court decide time limit for pocket veto? It can, but it should not. There is a difference. It can do anything, but it should not. It should stay away because there is separation of powers, which is part of the basic structure. If the president cannot tell the Supreme Court that on Mondays you should hear PILs, on Tuesdays you should hear another cases, on Fridays you should not hear any case at all. Can president say this to the Supreme Court? No, because you can't interfere in each other's organs. President use pocket veto after suspensive veto? No. If the president is a rubber stamp and has no discretion, what is the significance of the office? Why to have the president? This is to ensure continuity. Because previously also, we had a prime minister and the governor general. Prime minister continues after independence. Governor general is replaced by the president. Same continuity should continue. Also, there may be a time when prime minister is not there. At that time, president becomes an important player. Just like there may come a time where there is no chief minister. The governor plays a very important role in running that state. We have not discussed finance bill or financial bill. We will discuss it later. This president is the constitutional slave of prime minister and his council of ministers. Now, this term slave you should not use. It is the constitutional obligation of the president to go by the aid and advice of the prime minister and his council of ministers. Don't use such terms in your answers, slave and others. Because we will revisit the office of president when it comes to the office of vice president, when it comes to prime minister and his council of ministers, when it comes to attorney general for India, when it comes to legislature. So throughout our lectures, starting today, or should we say starting yesterday, till close to next Friday, we will keep on revisiting the office of the president. So we have not completed president in its entirety, but you have sufficient knowledge of the office of the president now, which now you will be able to better comprehend and understand. Vice president. Who is the vice president of India? What are the qualifications? How is the vice president elected? What is the term? What are the functions? Let's discuss the office of the vice president. We say Article 63 says there shall be a vice president of India. But the implication is this office can remain vacant as well. What if president dissolves both houses if he comes to know about impeachment? President cannot dissolve Lok Sabha without the advice of the prime minister. President cannot dissolve Rajya Sabha because Rajya Sabha cannot be dissolved. It is the permanent house of Indian Parliament. We will discuss. Article 63, there shall be the vice president of India, but we say it is not similar to Article 52, which says there shall be a president of India, because the office of the president can never remain vacant. But the explanation of Article 63 is office of the vice president can remain vacant as well. This is not such an important office. How and why? Let's discuss one by one. Article 64 talks about the role that is to be played by the president or the vice president. It says the vice president is the ex officio chairman of Council of States. And what is Council of States? Rajya Sabha. Gunjan sir, please clear it, sir. But Lakshmikant says on money bill, president have to give his assent. She have no option but to sign this bill. No, my dear. If I don't think Lakshmikant is mentioning this, even if it does, then Lakshmikant is wrong. And there are quite a few errors in Lakshmikant. On money bill, the president may either give her assent or publicly declare that I'm not going to sign this bill, withhold her assent to a bill. So on a money bill, the president can use absolute veto. And this is absolutely right. Clear? Trust me on that. Lakshmikant then is wrong. But let's not go money bill and financial bill way. Let's discuss vice president. Otherwise, Mr. Dankar would be deeply affected. So let's discuss him. Then in parliament, we will discuss all these bills, and then this question would be clear. Okay. Vice President to be the ex officio chairman of Council of States. Council of States means Rajya Sabha. So what is the role of the Vice President? Vice President is the chairman of Rajya Sabha. What is the role of the chairman of Rajya Sabha? Just like the role of the Speaker of Lok Sabha. What is that role? As the chairperson of Rajya Sabha, I am now the class monitor of Rajya Sabha. Please sit down. Please, you have to say something. Please say. Don't look at them while you are talking. Look at me. Look at the chair. Don't use abusive language. Just like Meera Kumar as the Speaker of Lok Sabha would say, "Baith jaiye, baith jaiye." When nobody is baith jaiye, the house is adjourned. That means like a class monitor ensuring the decorum of the house, ensuring that the house runs properly. And when the house is not running properly, the chairperson says, the house is adjourned. Let's meet tomorrow. The house is adjourned. Let's meet after 1 hour. Please don't destroy the property. Please don't throw mic at each other. Please don't come to the well of the house. Please don't do this. Please don't do that. Or let's take up this bill for discussion. Let's take this bill for voting. That means ensuring the business of Rajya Sabha. That is the job of the chairperson of Rajya Sabha. But we say Vice President is the ex officio chairperson of Rajya Sabha. What does that mean, ex officio? Vice President is not the MP of Rajya Sabha. Parliament consists of President, Rajya Sabha, Lok Sabha. Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, Attorney General for India. This Vice President is not a member of Parliament. This Vice President is not a member of Rajya Sabha. When you are not a member of Rajya Sabha, how can you preside over the Rajya Sabha? How can you be the chairperson of Rajya Sabha? It's because you hold an office. And what is that office? Office of the Vice President. That means it's not like Mr. Dankar is the chairperson of Rajya Sabha because who he is. No. He is the chairperson of Rajya Sabha because he occupies the post, the office of the Vice President. Tomorrow, if I am the Vice President of India, by virtue of me holding the office of the Vice President, by virtue of that office, I also become the chairperson of Rajya Sabha. Tomorrow, if you become the Vice President of India, you will be the chairperson of Rajya Sabha. Which means whoever is the Vice President of India, that person is the chairperson of Rajya Sabha. Despite the fact that you are not a member of Rajya Sabha. But you are the chairperson of Rajya Sabha by virtue of you holding that office. And that office is the Vice President of India. That is role number one of the Vice President. The Vice President is to be the ex officio chairperson or the chairman of Council of States. Provided that during any period when the VP acts as the President, he shall not perform the duties of the chairman of the Council of States. There shall be a President of India. That means this office of the President can never remain vacant. Let's say we have the President, she is performing her duty. We have the Vice President also who is performing his duty of the chairperson of the Council of States. What if the president's office is now vacant because of resignation, because of death, because of impeachment? Then who will occupy the post of the president? Because this post can never remain vacant. Vice president will act as the president of India. Now the vice president will sit in the Rashtrapati Bhavan, will act as the president of India. But then who will act as the vice president? Nobody. And this president, who is basically the vice president, but is now acting as the president of India, can I act as the president of India as well as act as the chairperson of Council of States? Can I perform these functions together? No. If I am the vice president, I will be the chairperson of Rajya Sabha. The moment there is a vacancy in the office of the president, I will act as the president of India. But I cannot perform both the roles. I can only be at the same time acting as the president of India. At the same time, I cannot be the chairperson of Council of States as well. But then who will be the vice president during this period? Nobody. That is why we say this office can remain vacant as well. But what is the principal role of the vice president? To act as the chairperson of Rajya Sabha, to be the chairperson of Rajya Sabha. So when you are not the chairperson of Rajya Sabha, because you are acting as the president of India, who will be the class monitor of Rajya Sabha? Who will say, "Baith jaiye, baith jaiye"? That person is the deputy chairperson of Rajya Sabha. So vice president, constitution says, we will have a vice president. But what is the role of the vice president? Role is, there are basically two roles that this vice president has to perform. One is the chairperson of Rajya Sabha. The second is, when there is a vacancy in the office of the president, this vice president acts as the president of India. These are the only two roles. But when this vice president is acting as the president of India, does that mean the office of vice president remains vacant? Yes. But then this vice president plays an important role as the chairperson of Rajya Sabha. Who will then act as the chairperson of Rajya Sabha, or who will perform the duties of the chair of the Rajya Sabha? That duty will be performed by the deputy chairperson of Rajya Sabha. And this vice president, how is the vice president elected? By the electoral college. But this time the electoral college is different. What is the electoral college of the president? Elected members of Lok Sabha, Rajya Sabha, elected members of the state legislative assemblies, including Delhi and Puducherry. But when it comes to the election of the vice president, we say the vice president is elected by the electoral college consisting of members of both houses of the parliament. That means electoral college of the vice president includes elected as well as nominated MPs. Because vice president will be elected by the electoral college consisting of members of both houses of the parliament, both Lok Sabha as well as Rajya Sabha. That means elected as well as nominated MPs. And elected based on proportional representation system by means of single transferable vote through secret ballot. What is the secret ballot? That means when MPs of both Lok Sabha as well as Rajya Sabha, they have to vote. They can't show their preference to anybody. They can't display their vote to anybody. This voting will take place through single transferable vote. That means if there are three candidates contesting the election of the vice president, you can give three preferences. My first preference is A, my second preference is B, my third preference is C. And then whoever gets more than half of the valid votes, that person is the vice president. But what if in first round of counting, we don't get anybody with more than half of the valid votes? Then the person with the least number of votes is eradicated. And then his first preference votes are transferred. That's same as that of the president. Proportional representation system. Proportional representation system in the sense that when it comes to parliament, BJP will have those many votes as their MPs in Rajya Sabha and Lok Sabha. Congress will have as many votes as they have the MPs in both houses of the parliament. That means in proportion to your strength in Lok Sabha and Rajya Sabha, those many votes will be allocated to you. Proportional representation system. And once you are elected, for that we need to first understand who is qualified to contest election to the post of the vice president. Same qualification as that of the president. You should be the citizen of India. You must have completed 35 years of age. You should not be holding any office of profit, which we will discuss later. And you should be qualified to become a member of Council of States. Which means you should be a registered voter in any parliamentary constituency of the country. So now means Deputy Chairperson of Rajya Sabha is the Vice President of India. Deputy Chairperson of Rajya Sabha is the Deputy Chairperson of Rajya Sabha. He is not the Vice President of India. He would have been the Vice President of India if he would have been elevated to that post. He is performing his own duty because Deputy Chairperson of Rajya Sabha has the same job. Whenever there is Vice President is not present, he becomes the chair. He is the presiding officer of Rajya Sabha. But we can't say that Deputy Chairperson of Rajya Sabha is now the Vice President. No. Because Deputy Chairperson of Rajya Sabha even then has to perform the role of the presiding officer of Rajya Sabha in absence of the Vice President. Clear? So he is not taking the role of the Vice President. He is taking his own role. Which means when there is no Vice President, you will be the presiding officer of the Rajya Sabha. Till 2003, there was a requirement. What was the requirement? If I have to contest elections to Rajya Sabha from Karnataka, I should have been the registered voter of Karnataka. If I have to contest Rajya Sabha election from Uttar Pradesh, I should have been the registered voter from Uttar Pradesh. But in 2003, Representation of the People Act was amended. Now the qualification is, if you are a registered voter in any parliamentary constituency of this country, you are eligible to contest Rajya Sabha elections. That is why Dr. Manmohan Singh for 10 years, although he was a registered voter from Delhi, he was the member of Rajya Sabha from Assam. Now I think he is the member of Rajya Sabha from Rajasthan. That means you should be a registered voter in any parliamentary constituency of this country, just like the same eligibility is for Lok Sabha. That is why original constitution said you should be eligible to become a member of Rajya Sabha in order to contest elections to the post of the Vice President. Because eligibility for Rajya Sabha and eligibility for Lok Sabha was different. But now it's the same. Which means for the President, what are the qualifications? You should be the citizen of India, must have completed 35 years of age, should be eligible to become a member of Lok Sabha. You should not be a member of Lok Sabha. If you are a member of Lok Sabha, resign and then contest election. That's how Pranab Mukherjee did it. Resigned and contested elections. And you should not be holding an office of profit. Similarly, in order to contest Vice President's election, you should be the citizen of India, must have completed 35 years of age, should be eligible to become a member of Rajya Sabha. You should not be a member of Rajya Sabha. Should be eligible to become a member of Rajya Sabha, which means your name should be mentioned in the registered voter list of any parliamentary constituency of this country. And you should also not be holding an office of profit. Once you're eligible, once you're qualified, you contest the election. And you are elected by the Electoral College. An Electoral College consists of members of both houses of the parliament through a system of proportional representation system by means of single transferable vote through secret ballot. Something we discussed with respect to the office of the president as well. Clear? And once you are elected, Your term is for 5 years. Term of the president 5 years, term of the vice president 5 years. But even before 5 years, there may arise a vacancy. Vacancy can be because of resignation. Resignation, vice president sends resignation to the president. Who shall act on the resignation? Which means who shall accept that resignation. It is binding on the president to accept that resignation. Which means if the term of vice president is 5 years, even before 5 years, there may arise a vacancy. Vacancy can be because of resignation. Vice president resigns by submitting his resignation to the president, and it is binding on the president to accept that resignation. That means now there is a vacancy. What will happen to this post of vice president? It will remain vacant. And within 6 months, Election Commission of India shall hold elections. Vice president has resigned. Now there is no vice president. Nobody would lose his or her sleep. Election Commission of India will say, okay, since there is a vacancy, we have got 6 months. Within 6 months, we will fill this vacancy. We will organize elections. We will hold elections. And we will get the Vice President of India elected. Don't worry. Why? Because what is the job of Vice President? The job of the Vice President is to act as the President of India when there is a vacancy. So we have the President, so let's not worry. What is the job of the Vice President? To preside over the sessions of Rajya Sabha. Even if there is no vice president, don't worry, we have the deputy chairperson of Rajya Sabha. He or she will preside over Rajya Sabha. Don't worry, don't lose your sleep. Or the vice president may die. In this case also, don't lose your sleep. He died. What can we do? Om Shanti, but okay. We still have a president, so we don't need vice president now. We still have deputy chairperson of Rajya Sabha, so we don't need vice president now. We have 6 months, we will get somebody elected to the post of the vice president. It's not such an important office. Or the vice president can be removed under Article 67, Clause B of the Constitution. I know some of you would ideally want a break, but we will finish this vice president portion and then I will give you a break so that there is no break in our discussion on vice president. Otherwise, Mr. Dankar would be angry. Okay? Very good. Just be with me. It's a very interesting thing. What are the grounds on the basis of which the president is impeached from his office? We say the grounds are a violation of the Constitution. What are the grounds on the basis of which the Chief Justice or the judges of the Supreme Court and High Court can be removed? Misbehavior or incapacity. That's something that we discussed. What are the grounds on the basis of which the Vice President is removed from his office? No grounds mentioned in the Constitution for the removal of the Vice President. There are no grounds mentioned in the Constitution saying on these grounds the Vice President can be removed from his office. No grounds are mentioned. That means the Vice President can be removed on any ground. Can the Vice President be removed on the grounds of violation of the Constitution? Yes. Can the Vice President be removed on the grounds of corruption? Yes. Can the Vice President be removed on the grounds of misbehavior? Yes. Can the Vice President be removed on the grounds of proved incapacity? Yes. Can the Vice President be removed for slapping you? Yes. Any ground can be used to remove the Vice President. It's just that the grounds are not mentioned. But the process is mentioned. And what is the process? This process shall initiate in the Rajya Sabha. If Rajya Sabha passes a resolution by a majority known as effective majority, what is effective majority? Majority of all the then members of the House. This is where your Lakshmikant is wrong. Lakshmikant says Vice President is removed by absolute majority, which is absolutely wrong. Vice President is removed by effective majority. And what is this effective majority? Listen to me carefully. For example, 500 is the total strength of the House. For example, 100 members, their seats are vacant. 100 members are absent. 300 people are present as well as voting. What is effective majority? What is simple majority? Total strength is 500. 100 seats are vacant and 100 MPs are absent. What is the difference between abstention and vacancy? Absent means Mr. Modi is traveling throughout the country, throughout the world, North Pole, South Pole. Rahul Gandhi is busy in Bhutan or Italy or Madagascar, wherever. And some other MPs of Lok Sabha, they are busy campaigning for elections in MP, in Chhattisgarh, in Rajasthan. So these are the people who are absent. They're still members of Lok Sabha, but they're absent. Then we may see that there are some seats which have remained vacant. Vacancy can be because, let's say, 20 MPs have been disqualified. Under anti-defection law, which we will discuss in schedules, 20 MPs have been disqualified. That means when 20 MPs have been disqualified, that means these seats are vacant. Now, nobody is representing these seats because whoever was representing, they have been disqualified. If you are still representing the seat, but you are absent, no worry, tomorrow you will come back. Day after you will come back. That means there is no vacancy. You are only busy traveling to different parts of the world, but you are still a member of the parliament. But what if 20 MPs have been disqualified for violating anti-defection law? These seats are vacant. That's what we call vacancy. Remaining 80, for example, they were traveling in an airplane and luckily the plane crashes. 80 MPs die, which means death causes vacancy. That means there is nobody who to represent these 80 constituencies. Total strength of the House minus vacancy is what we call effective strength. And more than half of effective strength is what we call effective majority. What is the effective strength? 500 minus vacancies. 400. What is more than half of effective strength? 201. So effective majority is 201. What is simple majority? More than half of the members present and voting, which means 151. Which means what is the difference between simple majority and effective majority? In simple majority, we take into account only those who are present and those who are voting. We don't take into account vacancies. We don't even take into account those who are absent. But in effective majority, we take into account what is the current strength or existing strength of Lok Sabha. Whether you are present in Lok Sabha or not doesn't matter. Whether you are absent or not doesn't matter. But since you are still a member of Rajya Sabha, we will include you in calculating the majority. Which means we only exclude those who are vacant. Where the seats are vacant, we exclude them. Which means if 500 is the total strength of the house, out of 500 there are, let's say, 200 people present and voting. What if the vice president is to be removed by effective majority? All 200 people are present. All 200 people say yes, vice president should be removed. Even then you can't remove the vice president. Why? Because effective majority is 201 plus. Because we don't take into account those who are present and voting and say half of those who are present and voting. That would be simple majority. We take into account what is the strength, existing strength of Rajya Sabha. If 500 is the total strength, 100 are vacant, 400 becomes the existing strength. More than half of 400, 201 becomes the effective majority. That is why the term used for this is majority of all the then members of the House. Those who are the members at that time, minus vacancies. And Article 67 Clause B says the Vice President shall be removed from his office. The grounds are not mentioned if a resolution is passed by Rajya Sabha by effective majority. And then this resolution should be accepted by Lok Sabha by simple majority. I am the Vice President. I got elected for 5 years. Even before 5 years, there may arise a vacancy. I may die, I may resign, or I may be removed. How will I be removed? Grounds are not mentioned in the Constitution. There are no explicit grounds on the basis of which the Vice President shall be removed from his office. Which means the Vice President can be removed on any ground. Violation of the Constitution, misbehavior, corruption, any ground. But the grounds specific are not mentioned. But the process is. This process must initiate in Rajya Sabha because I am the chairperson of Rajya Sabha. If Rajya Sabha passes a resolution by effective majority, which means majority of all the then members of the House, then this resolution should be sent to Lok Sabha. If Lok Sabha also accepts this resolution by simple majority, by passing a resolution by more than half of the members present and voting, then Vice President is removed from his office immediately. The Vice President is gone, is removed. Until date, no Vice President has been removed. And once the Vice President is elected, he has to subscribe to oath or affirmation. And what is this oath or affirmation? Oath is for believers, affirmation is for non-believers. I swear in the name of God, or I solemnly affirm that I will bear true faith and allegiance to the Constitution of India and that I will faithfully discharge the duty upon which I am about to enter. Which means Vice President does not take the oath to preserve, protect and defend the Constitution, unlike the President. He takes a simple oath that I will faithfully discharge the duty of the office about which I am about to enter. This oath is administered by the President. I am administering you oath. You are now the President. You are now the Vice President of India. Clear? Article 70 empowers the Parliament to make provision for the discharge of functions in any contingency not provided in the Constitution. What does that mean? If there is a situation which is not provided by the Constitution, how do we tackle the situation? For that, power is with the Parliament. You can make a law. And what is that situation? It happened. 1969, Zakir Hussain, as the President of India, suddenly passed away. Who was the Vice President? V.V. Giri. V.V. Giri was the Vice President. He now acts as the President of India. But V.V. Giri decides I should also resign. Why? Because I don't want to remain the Vice President or acting President only for 6 months. I want to become the full-fledged President of India. For that, I have to contest elections. And if I have to contest elections, I have to go to my voters. I have to go to every state legislative assembly, telling them why you should vote for me, urging them why you should vote for me. Because if I am acting as the President of India, I cannot go and ask for votes. That is why I have to resign. But now came a contingency which is not provided in the Constitution. What is that situation? In absence of the President, Vice President will act as the President of India. But what if now this President has to resign? President will have to submit resignation to Vice President, but there is no Vice President. What if this President, who is now the acting President, what if he has to go? Someone else has to occupy this post, and this someone else has to be Vice President, but there is no Vice President. Oh my God, what do we do? The government told V.V. Giri, please wait. You want to resign? Please wait. But first, let's pass a law to deal with this situation. Because you have to submit your resignation. To whom will you submit the resignation? Vice President, there is nobody. In your absence, Vice President has to act as the President of India. Who is that Vice President? Nobody. Right? So there is a peculiar situation. Let us pass a law. You sign that law, then you resign. And it is this law which is known as President Discharge of Functions Act 1969. This law says, whenever there is a vacancy in the office of the President, next in line, who will act as the President of India? Vice President. If there is a vacancy in the office of the Vice President as well, who will act as the President of India? Chief Justice of India. If there is no Chief Justice of India as well, who will act as the President of India? Senior Judge of the Supreme Court. And we will have at least one of these 33 judges who will act as the President of India. But sir, there is a problem. Yes, my dear, what is the problem? Constitution says under Article 50, what does it say? There shall be separation of power between executive and judiciary. President is the head of the executive. Chief Justice is part of the judiciary. How can a Chief Justice be part of the executive? Is it not violating separation of powers? It is not. Why? Because in 1969, when Zakir Hussain passed away, when V.V. Giri, who was acting as the President of India, also decides to resign, then Justice Hidayatullah, the Chief Justice of India, he left his post of the Chief Justice, is now acting as the President of India. That means while you are acting as the President of India, Chief Justice, you are not a Chief Justice. You are acting President. Who will be the Chief Justice? The next senior most judge will be the acting Chief Justice. So that Election Commission of India can organize elections. And within 6 months, there will be a new president who will be elected. At that time, I was the acting president. What will I do? Previously, I was a judge. I was the Chief Justice. I will go back to being the Chief Justice of India. Which means you are only acting as the president. Once the president is elected, you come down and you resume your position as the Chief Justice of India. And that's exactly what happened. Long story short, how to deal with contingencies which are not provided in the constitution, such as if there is a vacancy in the office of the president, vice president will act as the president of India. These were the only things mentioned in the constitution. What if there is no president, there is no vice president either? Then what do we do? There is a contingency, there is an emergency. In that case, the parliament enacted a law known as President Discharge of Functions Act 1969. And according to this act, if there is a vacancy in the office of the president, vice president will act as the president of India. If there is a vacancy here as well, Chief Justice of India will act as the president of India. But you cannot be the Chief Justice and president at the same time. Just like you cannot be the chairperson of Council of States and president at the same time. You can only act as the president of India. You cannot be the Chief Justice of India as well, which means we are not violating separation of powers. If Chief Justice also is not present, then in that case, a senior judge of the Supreme Court will act as the president of India. And once the election is over, we have a new president, this individual will go back to judiciary. That is Article 70 of the Constitution. And then reach the top post. So first you have to go to the vice president, then jump to president. Vice president post is immaterial. Directly take the post of the president. Deputy VP member of Rajya Sabha. When did I say we have a deputy vice president? Did I say that? There is no such post as deputy vice president. Deputy and vice are same. We have a deputy chairperson of Rajya Sabha who is a member of Rajya Sabha. Possible for election commission to organize elections within 6 months. Election commission can delay, but only due to act of God. Because of these reasons, we cannot organize elections. So it's an act of God. Only in the matters of act of God, election commission can delay the conduct of elections beyond 6 months. Otherwise, within 6 months, you have to hold elections. And vice president will not be removed, he will continue. And any dispute arising out of the election of the president or vice president shall be inquired into and decided by the Supreme Court, whose decision shall be final. For example, Pranab Mukherjee, he contested election to the office of the president. His opponent was P.A. Sangma. P.A. Sangma alleged that after the election that Pranab Mukherjee should be disqualified. His election should be set aside. Why? Because Pranab Mukherjee was holding the post of the Indian Statistical Organization, Indian Statistical Institute in Calcutta. He was the member of that institute. And as a legislator, as the president, you can't be holding an office of profit if you have to contest elections. Since he was holding the office of the chairperson of Indian Statistical Institute in Calcutta, which means you are holding an office of profit, you should be disqualified. This matter reached the Supreme Court because any dispute vis-a-vis the office of the president or the vice president, such a dispute can be filed only in the Supreme Court, and the decision of the Supreme Court is final. And the Supreme Court said, no, Pranab Mukherjee, although he was the chairperson of Indian Statistical Institute, but he had resigned from that institute before he filed his nomination papers. Which means at the time he filed his nomination papers to contest election to the post of the President of India, at that time he was not holding an office of profit. He was not holding the post of the chairperson of Indian Statistical Institute. Which basically means any dispute regarding the election of office of the President or Vice President, such a dispute, such a case can be filed only in Supreme Court. Not in Delhi High Court, not in any other High Court, but only in the Supreme Court. And the decision of the Supreme Court shall be final. That is effective strength. And more than half of effective strength is effective majority. Now give me 5 more minutes. I will finish this comparison between Indian and US Vice President, then I will take a break. I promise I'll give you a break. A Vice President as well. In India, we have the President, we have the Vice President as well. Clear? Indian Vice President and US Vice President, they have one thing in common. Both are chairpersons of the upper house of their respective parliaments. In US, we say they have a Congress. In India, we say we have a parliament. US Congress is bicameral, that means they have two houses, Senate and House of Representatives. In India, we say we have a bicameral legislature. One house is Lok Sabha, the other house is Rajya Sabha. Rajya Sabha is the upper house of Indian Parliament. Senate is the upper house of US Congress. Senate is headed by US Vice President. Rajya Sabha is headed by Indian Vice President. That means we can compare Indian Vice President with the US Vice President. In US, Vice President is the chairperson of the Senate, head of the Senate. In India, Vice President is head of the upper house, which is Rajya Sabha, which is the chairperson of Rajya Sabha. But then there is a difference as well. What is the difference? United States and India. The President of the United States has a term of 4 years. The President of India has a term of 5 years. What if in India, the President's office got vacant after 2 years? Vacancy can be because of death, resignation, or impeachment. What if after 2 years, there is a vacancy? What will the Vice President do? Vice President will act as the President. Till what time? Till the successor is elected, or 6 months? Which means if in India, the President's office is now vacant, which cannot remain vacant because somebody has to occupy this post, Vice President will act as the President of India. For how long? Till the time successor is elected, or 6 months. That means within 6 months, Election Commission has to necessarily organize elections, hold elections to elect the President of India. Till that time, I as the Vice President will act as the President of India. Or Election Commission may decide to hold election in 1 month. And in 1 month, we have the successor. In 1 month, we have the next president. And now this Vice President will go back to the office of the Vice President because we have a president who has been elected. That means maximum time that the Vice President can act as the President of India in India is 6 months. But in United States, if the term of president is 4 years, what if after 1 year there is a vacancy? In that case, the Vice President, Kamala Harris, will become the President of the United States for the remainder of the term. That is why when opponents in United States, they are contesting, they want to contest elections, they say don't vote for Joe Biden, because voting for Joe Biden would mean you're voting for Kamala Harris, because Joe Biden is sick. If you look at his movements, if you look at his cognitive abilities, He will die anytime soon. So basically, you will have a Kamala Harris becoming the president of the United States. Which basically means if the term of the US president is 4 years, and after 1 year, if a vacancy has arisen, which means that the president has died, then what is the term left? 3 years. Vice president will become the president of the United States for the remainder of the term, which is 3 years. That's the difference between Indian vice president and the American vice president. In India, the vice president acts as the president of India for 6 months or till the time successor is elected. And in United States, the vice president becomes the president of the United States for the remainder of the term, whatever term is left. That's the difference between the two. If vice president work as the president, so how will doing the work of vice president? Someone else will preside over Rajya Sabha, and that person is the deputy chairperson of Rajya Sabha. Okay, that is it for now. We will meet. So, Council of Ministers, and what is the difference between Council of Ministers and the Cabinet? Union Executive consists of President, Vice President. These are the two institutions we have discussed. But the Office of President, we will keep on revisiting whenever we discussed other institutions, particularly legislature. The Office of Vice President, we will revisit again when we will compare it with the Office of the Speaker of the Lok Sabha. So what is an additional power which is given to the Speaker of the Lok Sabha, which is not given to the chairperson of the Rajya Sabha, that we will discuss in Union Legislature. Now we will discuss Prime Minister and the Council of Ministers. After that, we will take a look at previous year's question papers. Attorney General for India, we will discuss on Monday, and on Monday, we will start Union Legislature as well. And please, 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 even if you have missed some of these lectures, but don't miss the lectures of the next week. Those are going to be the most important ones for your mains as well as prelims examination. Clear? We say Constitution has provided for a parliamentary form of government. And we say one implication of that, or one definition of a parliamentary form of government, is that Council of Ministers are responsible to Lok Sabha. Which means the Prime Minister and his Council of Ministers, as long as they have the majority in Lok Sabha, they will survive. The moment they lose majority in Lok Sabha, they have no other option but to resign. And we say the majority required for Prime Minister and his Council of Ministers to survive is simple majority. Even if the Prime Minister and his Council of Ministers, they do not enjoy simple majority in Rajya Sabha, doesn't matter. Why? Because parliamentary form of democracy means Council of Ministers are responsible to Lok Sabha. Why Lok Sabha? Because Lok Sabha is directly elected by the people. Rajya Sabha is not directly elected by the people. We will discuss on Monday how Rajya Sabha MPs are elected. But Rajya Sabha MPs are basically elected by the MLAs. So if there are 31 vacancies, 31 seats in the Rajya Sabha allocated to UP MLAs will vote to elect these 31 MPs to Rajya Sabha. Which means Rajya Sabha MPs are not directly elected by the people. But parliamentary form of democracy means government should be accountable to public. Government should be responsible to the public. And this government, which is Prime Minister and his Council of Ministers, they are accountable to public because public is electing members of Lok Sabha directly. That is what we call parliamentary form of government or parliamentary form of democracy. Article 74, which we have discussed, it says there shall be Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice, provided the President may ask for reconsideration of that advice. But once the advice is given, the President will have to act on that advice which has been retendered by the Prime Minister and his Council of Ministers, which basically means we have something known as the de facto and de jure. Who is the de jure head of the government? President. Which means according to the law, according to the constitution, who is the head of the government? Because we say all executive powers are vested in the name of the president. So the real power is with the president. But president exercises these powers only on the advice of the Prime Minister and his Council of Ministers. So by the fact of it, de facto head is the Prime Minister. Or should we say head of the state is the president, head of the government is the Prime Minister. As soon as elections are over, the first step is choosing the Prime Minister. Article 75 says, the Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on the advice of the Prime Minister. That means whenever elections are held, Lok Sabha elections are held, which happens after every 5 years, the immediate next step is that we have to form the government. That means we have to find a Prime Minister. And this is where the President has some discretion. Can President appoint anybody as the Prime Minister? Yes. But normally, President appoints a Prime Minister who is the leader of a party which has won the elections. Listen to me carefully. Is Prime Minister directly elected by the people? No. People directly elect their MPs, their representatives in Lok Sabha. And then these representatives have to choose one amongst them as the leader, and this leader will be appointed as the Prime Minister by the President. For example, in 2019 Lok Sabha elections, 543 MPs were elected. Now they have to choose one person as the Prime Minister. And normally it is the person who has the majority in the Lok Sabha. Which political party has the majority in Lok Sabha? The BJP. The BJP decided to nominate Mr. Modi, and Mr. Modi was appointed as the Prime Minister. Same happened in 2014 as well. People elected 543 MPs. Now these 543 MPs will have to choose one person as the leader, and this leader will be appointed as the Prime Minister. But this leader has to command majority in the Lok Sabha. Some members would say Rahul Gandhi is our leader, but you have got only 44 supporters. Some members will say Mr. Modi is our leader, but he has got 282 supporters, 282 MPs supporting him, which basically means the leader of the party which has won the election, that person will be appointed as the Prime Minister by the President. But can President, even if Mr. Modi's party has won the election, can President appoint me as the Prime Minister? Yes, he can. But I will not survive for long. That doesn't mean Mr. Amit Shah will get me killed. It only means that even if I am appointed as the Prime Minister, I have to be responsible to Lok Sabha. Which means as long as I have the simple majority in Lok Sabha, I will continue as the Prime Minister. But even if Mr. President appoints me as the Prime Minister, I am the Prime Minister, but now I have to prove that I have the majority in Lok Sabha. But I don't have the majority because majority of the members support Mr. Modi, which means I will have to resign. And then Mr. Modi will be appointed as the Prime Minister. Or the President would think that why appoint Sarmad as the Prime Minister? In any case, he does not have the majority, even though I like him. I will have to appoint Mr. Modi because he is the leader of the party which has won the election. But sometimes there is no political party which wins the election. For example, 2004. For example, 2009 elections. But in both these elections, Congress emerged as the single largest party. In 2009, 206 seats were bagged by the Congress party. But the simple majority would say more than half of the members present and voting. What if all the 543 members are present? That means this individual should have the support of at least 272 people, 272 MPs. This is how Congress got in touch with various other political parties, smaller political parties other than the BJP, saying, you support us, we will make you ministers, but you support us, let Mr. Manmohan Singh be the leader, and this Manmohan Singh will be appointed as the Prime Minister. And that is what we call a coalition government, where no political party on its own commands simple majority in Lok Sabha, which means then this political party requires the support of various other political parties so that they reach this magic number of 272. Such a government is what we call coalition government. Either it's a coalition government or it's a single party government. If the BJP on its own has the majority, it will become a single party government. If the Congress does not have the majority on its own, it will require support of various other political parties to reach this magic number of 272 plus. That means we call it a coalition government. And in that case, then, all these various political parties, they together choose a leader, saying Dr. Manmohan Singh is our leader. And then they approach the president. They give the president the list of the leaders. They give the president the list of the MPs who support Dr. Manmohan Singh. And once the president is satisfied that yes, this person has the majority in Lok Sabha, the president appoints this person as the prime minister. What if there is still no political party who is able to form the government on its own? No coalition government also is possible? Then the president has a discretion. He can appoint anybody as the prime minister. But once this person has been appointed as the prime minister, only on the advice of this prime minister can the president appoint other members of the Council of Ministers, other ministers. President cannot appoint someone else who has not been recommended by the prime minister. Yes, in choosing a prime minister, the president may have a discretion. The president may act on his own. But while the president has appointed the prime minister, only on the advice of the prime minister, other council of ministers are to be appointed. And then this prime minister and the council of ministers, whatever advice they tender to the president, that is binding on the president. And Article 74, Clause 2 says, the advice tendered by council of ministers to the president shall not be inquired into any court of law. Which means whenever Supreme Court has to take any decision, it has to go by the evidence. It has to go by the documents. It can inquire into the evidence. It can inquire into the documents to come to a point, to come to a verdict, to come to a judgment. But there is some amount of secrecy which is provided to the dealings of the government by the Constitution itself, saying whatever advice is given by Council of Ministers to the President, that cannot be inquired into any court of law. The court cannot ask the Prime Minister, show me what advice you have given the President. No, that's the limitation on the judiciary. The court cannot ask the President, please tell us what is the advice that was given to you by Prime Minister and his Council of Ministers. No, that is beyond the scope of judiciary. And the Council of Ministers shall be collectively responsible to Lok Sabha. What is this collective responsibility? For that, we need to understand what is collective responsibility and what is individual responsibility. Collectively, Council of Ministers and the Prime Minister, they are accountable to Lok Sabha. But individually, Council of Ministers and the Prime Minister are responsible to the President. What is the difference? Prime Minister is appointed by President. Individually, Prime Minister is responsible to the President. The president will have the power to ask the prime minister, how are you taking decisions? How are you acting on specific matters? What are the bills that you're trying to bring before the parliament? Please tell me. Because you individually, you are responsible to me. Individually, ministers are also responsible to the president. And this is what we call doctrine of pleasure. What is this doctrine of pleasure? That means the ministers hold office during the pleasure of the president. As long as the president is comfortable with these ministers will continue. The moment president loses the confidence of these ministers, withdraws his pleasure, these ministers shall be removed. But we are a parliamentary democracy where prime minister is the real head of the government. President is only a nominal head, a constitutional head. We say this doctrine of pleasure is not the personal pleasure of the president. It is basically the pleasure of the prime minister. Which means if the prime minister wants this minister to continue, prime minister will say, President, please appoint this minister. The moment this minister is to be removed, president will ask the prime minister will ask the president, remove this minister. That means this minister holds office during the pleasure of the president. But it is not the personal pleasure of the president. It's basically the pleasure of the prime minister. Only those ministers will continue, those who enjoy the confidence of the prime minister, those who enjoy the pleasure of the prime minister. For example, some months ago, there was a reshuffle of Council of Ministers. Some ministers were removed, new ministers were appointed by the president. For example, Dr. Ravi Shankar Prasad, Prakash Javadekar, they were removed from the post of ministership. But although they were removed by the president, which basically means they submitted their resignation to the president, but it was basically the pleasure of the prime minister. Prime minister did not want Ravi Shankar Prasad, Prakash Javadekar to continue as ministers. So prime minister asked them, you resign. And they submitted their resignation to the president. What if these ministers would have said, no, we will not resign? Prime minister will advise the president, dismiss those ministers. Because whatever advice I give the president, that's binding on the president. So although we say that on the face of it, it is the doctrine of pleasure, that means pleasure of the president. As long as I have your pleasure, you will continue. The moment I withdraw my pleasure, you will have no other option but you are gone. But this is basically the pleasure of the prime minister. At the same time, if you look at today's governor of Kerala, Arif Mohammed Khan, now we will come to collective responsibility. There are two implications of collective responsibility. Collectively, Council of Ministers are accountable to, responsible to Lok Sabha, which means as long as they have the majority in Lok Sabha, which is simple majority, they will continue. The moment they lose simple majority in Lok Sabha, that means they have no other option but to resign. Collectively, they are responsible to Lok Sabha. And collective responsibility also means that whenever a decision is to be taken, there may be disagreement. There may be conflicts. But once a decision has to be taken and has been taken, now collectively you have to support that decision because collectively you are the members of the Council of Ministers. For example, whether we should support Israel or Palestine in this conflict, Prime Minister may call the meeting of his ministers. What should be the stance of the government? Once the discussion takes place, some members may say, no, we should support Palestine. Some members will say, no, we should support Israel. But then we have to go by the majority. When more than half of the ministers, they say, no, we should support Israel, you have to support Israel. And all those ministers who were not in support of Israel, now they have to support it. Because you have to appear as if you are a collective institution. 1986, when Shah Bano verdict was given by the court, the Supreme Court said, you have to provide, the husband has to provide maintenance for her divorced wife for her entire life, not only for 3 months. How did the government react to this judgment? They introduced a bill in the parliament known as Muslim Women Protection of Rights on Divorce Bill. This bill is to be first cleared by the cabinet, which means ministers and the prime minister, they will discuss this bill and ultimately take a decision by the majority whether we should get this bill passed by the parliament or not. Arif Mohammad Khan was the minister in Rajiv Gandhi's government. He disagreed with this bill, saying, no, this is not the right bill. You can't go against the verdict of the court. The court has given a good verdict in favor of gender justice. But once all the other members of the Council of Ministers, they were in favor of this bill, Arif Mohammad Khan had two options. Either support this bill, because that is what collective responsibility says, or resign from the government. And he chose to resign from the government. He resigned from the Council of Ministry. Because if he would not have resigned, then he would have to support that bill. Why? Because that is collective responsibility. Not just this. There is no provision in the Constitution which makes President responsible to the Parliament for the acts of the government. A minister has done something wrong. Who has appointed this minister? President. Will we hold President responsible to the Parliament? Why did you appoint this individual? Why did you not remove this individual? No. There is no provision in the Constitution which makes President responsible for the acts of the government to the Parliament. It is the individual minister who is responsible collectively to the Lok Sabha. President is not accountable for the actions of his government before the Parliament. Why? Because President is a rubber stamp. Accountability should be of the Prime Minister. Accountability should be of the ministers, not the President. That's another important point. Further, what should be the total number of ministers? Let's say, for example, there is a political party, BJP, Congress, Communists, and others. All of us are contesting the election, Lok Sabha election. But no political party got the majority. That means single party government is not possible. What we have to do now? We have to see which political party is able to act like a magnet, attracting various political parties so that you achieve this magic number of 272. But why would other political parties support you? They need something in return. And what they need in return is that you want to become a minister. And over a period of time, this Council of Ministers list, it became so huge, so wide that almost everybody was appointed as a minister. Even the departments were split so that you can be appointed as a minister for this department, you can be appointed a minister of this department. Otherwise, this political party will not support me. But if the number of ministers increase, that means the number of expenditures also increase. That means number of cars, number of government vehicles, number of government bungalows, number of government staff, number of salaries will also increase. This was a huge burden on the state revenue. This was a huge burden on the state exchequer. This was a huge burden on the finances of the government. Thanks to Atal Bihari Vajpayee, when he was the Prime Minister, Constitution was amended. 91st Constitutional Amendment Act was passed. And now this 91st Constitutional Amendment Act fixes a limit. What is the limit? The entire Council of Ministers, including the Prime Minister, should not be more than 15% of Lok Sabha. Whatever is the total strength of Lok Sabha, 543, the Council of Ministers should not be more than 15% of the Lok Sabha strength. That means we can have 80 odd ministers, not more than that. Minimum number of ministers that can be appointed are 12. Maximum it can go up to is not more than 15% of the strength of Lok Sabha. And that is why we say minimum government maximum governance. If the number of ministers is not a huge list, it's not a huge number, it's a smaller number, an approachable number, a genuine number, they will be able to give maximum governance to the people. Minimum government, maximum governance. That was the motto, that was the slogan of Prime Minister when he came to power. We will have a smaller government so that a smaller government is able to get its costs under hand, gets its cost under check, and provide maximum governance to the people. Similarly, the ministers hold office during the pleasure of the president. And we know it is not the personal pleasure of the president, it's basically the pleasure of the prime minister. Before a minister enters upon his office, the president shall administer oath of office and secrecy according to the third schedule of the constitution. When the president is elected, he wins the election, the president is to be administered oath. I will faithfully discharge the duties of my office. I will preserve, protect, and defend the constitution. Clear? That oath is to be administered. Similarly, when a minister is to be appointed, two kinds of oaths are to be administered: oath of office and oath of secrecy. What is oath of office? That I swear in the name of God that I will bear true faith and allegiance to the Constitution of India, that I will faithfully and conscientiously discharge the duties as the minister of the state. That means as the union minister, I will discharge the duties to the best of my ability. But as a minister, I may also be privy to some sensitive information. What is the Rafale deal between India and France? Whether China has really entered into the line of actual control or not. Where are our nuclear weapons? Are our nuclear weapons in working condition or not? I'm privy to a lot of this information. I have to take oath of secrecy as well. I will not reveal this information to anybody, except when it is required. Which means it is required to reveal this information when we are, as ministers, discussing this matter. I can reveal this information to the Prime Minister. I can reveal such information if the Supreme Court is asking me to reveal it. But I will not reveal it to my relatives. I will not reveal it to my friends. I will not reveal it to the business people so that these business people are benefited from this information. Oath of office as well as secrecy. Plus, we say that in India, this Prime Minister can be either from Lok Sabha or Rajya Sabha. For example, in UK, the Prime Minister has to be from lower house, which is House of Commons. Because in Britain also, they have a bicameral legislature, where the British Parliament consists of two houses. House of Lords, which is upper house, House of Commons, which is lower house. House of Commons, they are directly elected by the people. And the Prime Minister has to be necessarily from House of Commons. But in India, there is no such a requirement. The Prime Minister can be from Lok Sabha, directly elected by the people. The Prime Minister can be Rajya Sabha, indirectly elected by the people. Mr. Modi is the Prime Minister, but he also is a member of Lok Sabha. Dr. Manmohan Singh was the Prime Minister, but he was the member of Parliament of Rajya Sabha. That means in India, this Prime Minister can be either from Lok Sabha or can be from Rajya Sabha. But can I be appointed as the Prime Minister today, despite the fact that I'm neither member of Lok Sabha nor Rajya Sabha? Yes, I can be. But for that, what I have to do? Within 6 months, I have to get myself elected to either Lok Sabha or Rajya Sabha. If within 6 months of my appointment as the Prime Minister, I'm getting myself elected to either Lok Sabha or Rajya Sabha, I will continue as the Prime Minister. Otherwise, I will have to resign. Because I am part of the executive. And we draw executive from the legislature. That's parliamentary democracy. If right now I am not part of the legislature, but I have to become part of the legislature within 6 months. If I am, I will continue as the Prime Minister. If I'm not, then I will cease to remain a minister. Similarly, a minister. For example, Dr. Subramanyam Jaishankar, External Affairs Minister, Foreign Affairs Minister. When he was appointed as the minister in 2019, he was not a member of Lok Sabha, nor was he a member of Rajya Sabha. He was still appointed as a minister. Could he have been appointed? Yes. But within 6 months, you have to get yourself elected to either Lok Sabha or Rajya Sabha. And within 6 months, he got elected to Rajya Sabha and continues as a minister. But if you cannot get yourself elected to either Lok Sabha or Rajya Sabha, within 6 months of your appointment, you shall cease to be a minister. So what is Prime Minister and his Council of Ministers? Prime Minister is appointed by President. On the advice of the Prime Minister, other Council of Ministers are appointed by the President. Prime Minister and his Council of Ministers, they are collectively responsible to Lok Sabha, but individually they are responsible to the President. The size of the Prime Minister and his Council of Ministers shall not exceed 15% of the Lok Sabha. And whatever advice we give to the President cannot be inquired into any court of law. And all these ministers hold office during the pleasure of the President, which basically means pleasure of the Prime Minister. Which means as long as Prime Minister wants you to continue as a minister, you will continue. The moment Prime Minister loses his pleasure in you, if you're not doing well, or if you're not listening to me, or I simply hate you now, I will ask you to resign. If you don't resign, I will ask the President to dismiss you. And it is binding on the President to dismiss this minister. Because whatever advice Prime Minister gives the President, that's binding on the President. The President may ask once, please, let's not dismiss Amit Shah. No, dismiss him. He's going against me now. President will have no other option but to dismiss the minister. That is the difference between collective responsibility and the individual responsibility. The salaries, allowances of the ministers shall be such as the Parliament may from time to time determine and shall be specified in the second schedule. Now we have discussed 4 schedules. Schedule 1 talks about names of the states and union territories. Schedule 4 talks about representation of states in Rajya Sabha. Schedule 2 talks about whenever the salary of these ministers or the parliamentarians are decided. Who decides their salary? Parliament itself. Till the time Parliament enacts a law determining the salary, that salary will be mentioned in second schedule. What is the salary of the President? Mentioned in second schedule. What is the salary of the Vice President? Mentioned in the second schedule. What is the salary of the Speaker of the Lok Sabha and other legislative assemblies? Mentioned in the second schedule. So second schedule talks about salaries. What is the salary of the judge? Mentioned in the second schedule. What is the salary of the CAG? Mentioned in the second schedule. And schedule 3 talks about oath. The oath of President is mentioned in the Constitution itself. The oath of the Vice President is mentioned in the Constitution itself. But what is going to be the oath of the minister? That is mentioned in the third schedule. What is the oath of the CAG? Mentioned in the third schedule. CAG also has to subscribe to an oath after he is appointed. What is the oath of the judge of the Supreme Court and High Court? That is also mentioned in the third schedule of the Constitution. But now let's look at what is the difference between Council of Ministers and the Cabinet. In mathematics, for example, if this is a superset, we call it Council of Ministers, including the Prime Minister. So all these 80 odd ministers who are appointed at the central level by the President to the central government, they become part of this wide term or the superset known as Council of Ministers. So Prime Minister and all the ministers appointed by the President, they are part of this group known as Council of Ministers. But within this Council of Ministers, there exists a subset. And that subset is what we call Cabinet. What is Cabinet? What is a Council of Ministers? Let's say, for example, we have a ministry. Let's say this Ministry of Home Affairs, MHA. It has various departments under it. So ministry is one, but it has various departments. For example, we have Department of Home, Department of Official Language, Department of States, Department of Internal Security, Department of Border Management, Department of Jammu and Kashmir and Ladakh Affairs. These are the 6 departments under Ministry of Home Affairs. Listen to me carefully. Constitution only says Prime Minister is appointed by the President. On the advice of the Prime Minister, other Council of Ministers are appointed. But does Constitution say and talk about Home Minister, External Affairs Minister, Finance Minister, Agriculture Minister, Science and Technology Minister? Does Constitution talk about all these ministers? No. Who talks about them? Allocation of business rules. Because Constitution has given the power to the President that you can make rules for the allocation of business. What is the business of the government? We have to maintain our internal security. We have to promote our economy. We have to ensure agricultural development. We have to ensure Panchayati Raj institutions. All this business of the government can be allocated to various departments, various ministries. And those names, Home Ministry, External Affairs Ministry, Finance Ministry, Agriculture Ministry, Defense Ministry, is mentioned in this allocation of business rules. Clear? That means names of the ministries are not mentioned in the Constitution. They're determined by the government. They're determined by the President on the advice of the Prime Minister. Which means tomorrow, if a new ministry is to be created, for example, couple of years ago, a new ministry was created. What is the name of that ministry? Can anybody tell me? Ministry of Cooperation. A new ministry was created. For that, you don't have to amend the Constitution. Why? Because Constitution does not talk about various ministries. For that, you just have to change these rules, amend these business rules of 1961. That means ministries are created by the President based on the advice of the Prime Minister. But let's come back to this question. All those ministers appointed, they are part of the superset known as Council of Ministers. But when we look at a ministry, it has various departments as well. Whoever is in charge of the entire ministry becomes a cabinet minister. So Amit Shah is a cabinet minister. Why? Because he heads the entire ministry. Rajnath Singh is a cabinet minister because he heads the entire defense ministry. Shrimati Nirmala Sitharaman, always angry. She is the cabinet minister because she is heading the entire finance ministry. But within finance ministry, there are various departments. Department of Revenue, Department of Expenditure, Department of Economic Affairs. Similarly, in Home Ministry, there are various departments. If there is a minister who is in charge of one department or one or more departments, those are what we call ministers of state. MOS. That means a minister of state reports to cabinet minister. Who is a cabinet minister? Somebody who heads the entire ministry. Who reports to this cabinet minister? Minister of state. And who is this minister of state? Somebody who is in charge of one or more departments within the ministry. Then we have somebody known as Minister of State with independent charge. And without realizing we have reached 9:25, we also have to discuss previous year's question papers. I'm sorry, I went with the flow. I did not realize. I thought I will teach till 9:10. Uh, and I also understand that some of you may have to go to office. So we will pause here and we will first look at previous year's question papers. We will discuss prelims based questions at least, and we can continue on Monday. Under the Indian Constitution, concentration of wealth violates what? This question was asked in 2021. Take the poll. This is the leaderboard. You have to be very quick. Laksh has his Laksh in sight. Under the Indian Constitution, concentration of wealth violates Article 39, Clause C. The operation of economic system should not result in the concentration of wealth to a common detriment. Should not result in the concentration of wealth in fewer hands. Article 39C is what? Directive principles of state policy. B is the right answer. Love the way you teach, sir. We also forget in this flow. That is reassuring. Let's look at another question. What is the position of right to property in India? Can a nominated MP of Rajya Sabha ever become Prime Minister? Yes. 44% students are right. Laksh has again topped. What is the legal position of right to property? It used to be a fundamental right, but now it's a constitutional right under Article 300 capital A. So when we say neither fundamental right nor legal right, it is wrong because it is a legal right. It's a constitutional right. Constitutional rights are legal rights. Fundamental right available to citizens only? No, it used to be a fundamental right, but now it is not. When it was a fundamental right, it was available only to citizens. Because Article 19 is applicable only to citizens. Now, once it has become a constitutional right, it is available to any person. So, legal right available to any person. If it was a fundamental right, it would have been available to citizens only. So, B is the right answer. Clear? Very good. Question number 13. Or this question was asked in 2013. Consider the following statements. First, I have to read the question. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also needs ratification by the legislatures of all the states. Which of the statements are correct? Okay. Tell me. Jashveer, you're wrong. Read the question carefully. These are our toppers. Congratulations. Continue. An amendment to the Indian Constitution can be initiated by the introduction of the bill in Lok Sabha only. Incorrect. Can be initiated in Rajya Sabha also. That's why I told you, look at the flow. This bill can be introduced by a minister or by a private member without the prior recommendation of the president in Lok Sabha or Rajya Sabha, in either of the two houses. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by legislatures of at least half of the states, not all the states. So this is also incorrect. Which of the statements are correct? D, neither one nor two. Very good. This question was asked in 2020 with reference to the provisions contained in Part 4. Part 4 deals with the directive principles of state policy. Which of the following statements are correct? They shall be enforceable by courts. They shall not be enforceable by any court. These principles laid down in this part are to influence the making of the laws by the state. So what is the correct answer? I'll take a poll. I know the answer. This is the answer. You tell me what is the answer. 74% students are right. Very good. Laksh, very good. Continue. DPSPs are not enforceable in a court of law. DPSPs shall not be enforceable in a court of law. And what are these DPSPs? These are the principles that the state has to keep in mind when the state is making laws. That means these are the principles that are used to influence the making of laws by the state. Correct 2 and 3. D is the right answer. Simple. Another question. Which principle among the following was added to the directive principles of state policy by the 42nd Amendment to the Constitution? Very factual question. That would be too much. That is not expected. That is why I can see that majority of the students are wrong. It is participation of workers in the management of industries. Although I can understand there was no way you could have remembered this. But this is something which was in the news in 2017. Air India should be privatized. For that, there was a lot of discussion in the newspapers which said, first you should involve the workers of Air India, get them into confidence whether they want it to be privatized or not. Otherwise, it would be violation of directive principle, which is workers should be involved in the management of the factories. Since it was in the news, that is why this question was asked. And it was added by the 42nd Amendment. Expectations upon legislative function, executive function. Directive principles are positive obligations. The state is asked to interfere to enhance the standard of living. So it's not a limitation. Fundamental rights are limitations. Directive principles are positive obligations. So these DPSPs are neither limitations on executive nor legislative function. DPSPs are not limitations. Fundamental rights are. D is the right answer. Which of these statements are correct? Good. Democracy. These are not enforceable in a court of law because that is the characteristic of DPSP under Article 37. So both these statements are correct. In the Constitution of India, promotion of international peace and security is included in rules of state policy. 2017, the main advantage of the parliamentary form of government is that the executive and legislature work independently. It provides continuity of policy and is more efficient. The executive remains responsible to the legislature. The head of the government cannot be changed without election. I will give you some. Manisha has moved a bit drawn from legislature in a parliamentary democracy. Executive and legislature worked separately, independently in a presidential form of government. It provides continuity of policy and is more efficient. Whether it is efficient or not, that is subjective. Some would say presidential form of government is more efficient because the decisions are taken quickly, right? The head of the government cannot be changed without election. But that is a republican nature, right? And that is not the feature of parliamentary alone. That's the feature of presidential form of government as well. Head of the state cannot be changed without election. The executive remains responsible to the legislature. Council of Ministers, who are part of executive, they remain responsible to Lok Sabha, which is also a legislature. So C is the right answer. Republic. And to secure to all its citizens justice. So very good. Some extra time for the directive principle. According to the Constitution of India, which of the following are fundamental for the governance of the country? Which constitution? Article 37. Directive principles are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement directive principles, because these directive principles are necessary for these are fundamental for the governance of the country. 15% of the total answer. 2017, which of the following constitutional amendments states that the total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members of the House of the People? This is something that very good. 79% Janta is correct. 91st Constitutional Amendment Act. 2007. The Council of Ministers in the Union is collectively responsible both to Lok Sabha as well as Rajya Sabha. The members of both Lok Sabha and Rajya Sabha are eligible to be ministers of the Union government. Responsible both to Lok Sabha and Rajya Sabha are eligible to be the members of the Union government. Correct. Subramaniam Jaishankar example. Dr. Manmohan Singh example. So A is false, but R is true. Question asked in 2012. The Prime Minister of India at the time of his or her appointment need not necessarily be a member of one of the houses, but must become a member of one of the houses within 6 months. Need not necessarily be a member of one of the houses, but must become a member of Lok Sabha within 6 months. Must be a member of one of the houses. Must be a member of Lok Sabha. But that's not the criteria for India. Need not necessarily be a member of one of the houses of the parliament, but must become a member of one of the house, either Lok Sabha or Rajya Sabha, within 6 months. Question 2017. Out of the following statements, choose the one that brings out the principle underlying cabinet, a mechanism for speeding up the activities of the government whose responsibilities are increasing day by day, a mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people, a device for strengthening the hands of the head of the government whose hold over the people is in a state of decline. Done with them. Minimizing criticism against the government whose responsibilities are complex and hard to carry out to the satisfaction of all. Whatever the statement is, it is incorrect. Yes, government's job is complex, but that doesn't mean that is the principle why we choose cabinet form of government. A mechanism for speeding up activities of the government whose responsibilities are increasing day by day. By that logic, what is the difference between presidential and parliamentary form of government? In presidential form of government also, you can speed up the process. In fact, that is quick. A device for strengthening the hands of the head of the government whose hold over a period of over the people is in a state of decline. And this is too vague a statement, too sweeping an argument, saying the head of the government, his position is on a decline, which is not the case. It's a parliamentary democracy where Council of Ministers, which is the government, is accountable to the people in Lok Sabha. Consider the, Attorney General we have not discussed. Okay. Rajya Sabha. Value of votes of all MLAs divided by elected members of parliament, which means value of vote of an MP of Lok Sabha is equal to the value of vote of an MP of Rajya Sabha. This is incorrect. So only one is correct. A is the right answer. Now the descriptive questions we will discuss on Monday. Till then, have a great time. Sorry, apologies for keeping you here till 9:46.